Boom. Hopefully I'm not too late. I didn't see people making Rob comparisons yet in the chat, so um, hopefully that means that it wasn't too long for me to get going. Sorry, folks. I had some trouble with my headphones just before I was starting up here. How is everyone doing? It is insanely hot where I am, so I hope that the air conditioner isn't generating too much background noise. Let me know if you guys can hear it, if it's causing problems. But I hope everyone had a good weekend. I hope that the return back to work is not too much of a challenge. But how is uh, how is everyone? I hope everyone's got something to sip on, whether it's whether it's a fun drink, whether it's whatever else. Water is a popular one right now because man, is it hot out. It's my wife planted some flowers out front, and they're struggling. Oh, and I see somebody's trying to phone me. Sorry, that'll have to come later. If it's important, hopefully they will text. Um, so, it is. It's really warm. Somebody was asking, how hot is it out here? I guess that's a good question. Let's pull that up. And the only people who call me usually are, when it's a private number, it's usually a spammer. So I can't say for certain. But temperature in Edmonton. Oh, and they left a voicemail, which is probably a spammer. It is 30 degrees Celsius or 86 Fahrenheit. I don't know if that's hot for other people, but it's quite warm for me. Oh, this is cool. I'm in latent print training all week. So forensic stuff. That sounds super cool. And I see Naked Superfood Machine Juice. I don't know what that is. Wow, 85 Fahrenheit. Yep. Long Island iced tea, nice. I like a good Long Island iced tea, although they're a bit of a pain. So just and I see I've got a bottle of Oberon Cab waiting for me, but I can't move because I have a dog asleep on my lap. Yep, once you got a dog asleep on your lap, it is the dog owns you. The dog owns the lap. That's just how that goes. Missy Dee Moo, sorry to hear you're sick. Drinking hot water and lemon. That's a good drink for when you're sick. But personally, my go-to when I'm sick is I mix some chicken sort of broth with garlic and enough hot sauce that a UN weapons inspector gets mobilized. That I find is that's my go-to to try to get unsick. Just getting over a cold, sipping salty watermelon whiskey. Nice. So I see people saying 30 isn't that hot, gets to 38 in Croatia. Fair enough. I mean, this is just the beginning, but Bobby Graham, hello from Indiana. Hello. Making a hot chocolate in England. I am not going to go for a hot chocolate right now. So that doesn't sound like a great plan. I'm going to start off with this. Dr. Brown's Celery. This is apparently a celery flavored soda. I picked this up at YEG Exotic. They sell all sorts of unusual drinks. And so we're going to try this. We're going to see if it's any good. It might be awful. It might be tasty. Who knows? All right. That's actually really good. That's actually really tasty. So I'm going to have to buy more of that. That's it does taste kind of like celery, but it's also kind of got a tangy flavor to it. It's got a bit of not really like a spicy bite, but kind of an interesting flavor to it. So that's a good one. Yeah, I think this one is a winner. I may have to see about getting more of that. It does kind of taste like celery, but it's refreshing. So, and somebody was asking when the new oven comes in. When does the new oven arrive? So if you don't know, my oven had a major failure. The door just completely collapsed on me, and so I've had to replace that. So that was an annoyance, but now that I'm going to get another one, so we're just going to have to see how that goes. But we'll that's arriving, and I went with a Frigidaire, so hopefully it's good. All right, now I should look at. It looks like we've got some gifted memberships coming in right off the start here. Thank you to Canonical Heat for 20 gifted memberships and Lady Draconis for 5 gifted memberships. I also want to thank Ang Torres, who before the stream started gifted a whole bunch of memberships. Ang Torres 20, and then another 10, and then another 8. So that's a huge number. Apparently, they can't be here for right now, but that is amazing. So fantastic to see you guys all here. So let's get started. We got a whole bunch of cases, a whole bunch of things going on to look at, and there's a lot of excitement going on these days in the legal sphere. We're going to look at some U.S. cases. We're going to look at some Canadian things. We're going to look at all sorts of stuff. I'm not going to do a whole lot on Bill C-21. And the reason why is that I'm going to be putting a bunch of videos out on Bill C-21 and what happened in committee, a bunch of the changes over time. So, yeah. Infinitely April is saying, is the Trials of the Century members only behind the scenes still up for new members to check out? It is. So you can check that out. So we can check that out. And I'm being told I got a swoop. And I've been told I need to get a better swoop. So that is that's a good one there. And we got a member chat question here. What is the principle of restraint? And is it true the Liberals brought in catch and release? So the principle of restraint is a principle in sentencing, and it basically says that we should impose the sort of where jail is not necessary, we shouldn't go with jail. Or where a lesser sentence would be appropriate, we should go with a lesser sentence. Basically, what it says is that the government wields a tremendous amount of power to incarcerate people. And because of that, we should, you can't really take incarceration back. And so therefore you've got to, be sort of reluctant to throw people in jail. That's basically what that one means. Now, is it true that the Liberals brought in catch and release? The bail principles that apply predate the Liberals. In fact, the bail principles that we're dealing with have been applying for a long time. Most of the changes that we've seen in the bail sphere is because of case law and applying the Charter of Rights. So basically, I don't, a lot of people are blaming the Liberals for the bail system. Everybody knows I'm not a fan of the Liberal Party, right? I mean, I think I've laid that out there. This one isn't really their fault. And ultimately, a lot of the things that they're looking for to fix it are probably not fixes. The bail issue is complicated because keep in mind, bail is for people who haven't been convicted of an offense. And if you haven't been convicted of an offense, there is entirely a possibility that you won't be convicted of the offense. And this is a good point there. Saw a reverse onus just today due to a prior conviction for domestic assault. In fact, they've imposed a whole lot of reverse onus charges to a degree that most people, like who end up in a bail hearing, a lot of people are there with reverse onus. And reverse onus means you have to justify why you should get out of custody and not why you should be detained. And I mean, keep in mind, you might well be innocent. So everybody sort of says, oh, we got to crack down on bail. But let's say right now, somebody kicked down the door and attacked me. Like somebody burst in and, started stabbing me. And I grabbed this thing because it's sitting right next to me. And I, gave them a couple of good smacks with this. And they ended up going to the hospital because this thing would really mess you up. Now I'm in jail because I really messed somebody up. And I think I should get out. Like, I think I should be allowed bail, right? I think that would be reasonable if you've got somebody who attacked me coming in there. So it's hard, right? So it's difficult. People should be able to, and that applies even when people have been charged with serious crimes, because you've got people like Ian Thompson, who was charged with serious stuff, and so forth. And CD is saying you've got more people on than EDB tonight. Well, that's a big achievement. But EDB's is a members only, and quite frankly, if anybody wants to catch me on replay because they're watching that, then fair ball. Somebody's asking, what are the typical bail conditions or undertakings? Typical bail conditions are no contact with whoever accused you of whatever, like whoever you're accused of doing something to, whether that be an assault or a theft. Often they'll impose no-go conditions to the specific place where it said to have happened. They may impose conditions of no weapons, no firearms. These are very, very common charges or very common conditions. So, yeah. What is that thing called? I'm not sure if I can pronounce it correctly, but a macahuitl. So it's an old Aztec weapon. So. All right. And somebody's asking, why don't I like the death penalty? I don't trust the government. And I've seen too many instances of wrongful convictions. I've seen too many instances of evidence held back. I don't trust it. So I would much rather, there's people I don't like. There's criminals who I think are terrible people, but the criminals I think are terrible people tend to die in custody, overall. And escapes are really rare. And typically when you're dealing with somebody like the people that people want the death penalty for, your Clifford Olsons and so forth, they don't tend to get parole until they're so old that they're like incredibly decrepit and they just can't function anymore. Right. So you've got, so I remember there was one guy, he'd killed 3 people and they were up in arms that he was getting parole. They're like, how come this guy's getting parole? And I looked into it. I saw why he was getting parole. He was getting parole because he'd had a stroke and was literally like, he couldn't move. He couldn't anything. He was just, sort of a lump of meat. So there wasn't much point keeping him in a prison at that point, because why? Pants, I see Ian, I watched a jury and got the verdict right. Nice. That's a good one. Becky, member chat, love watching you. Thank you very much, Becky. Much appreciated. Disney Cosmo, thank you for 5 gifted memberships. Much appreciated. It's appreciated there. Um, yeah, I don't trust the government to fill in potholes. I certainly don't trust them to execute the correct people and not the convenient people. Yep. And EVM saying in Canada, life should be life, not 25 years. In Canada, life is life. If you get a sentence of life in prison, you will be in the system for life. But you might get parole. But if you're on parole, you're actually on a really short leash. If you get parole and you commit any other offense, and it can be pretty minor. I've seen people who were like 60 years old and on parole for a murder, and they get busted for, back when it was illegal, having a little bit of weed, and they end up in custody because their parole gets revoked, and so they're in maximum security for having a little bit of weed afterwards. So I'm actually kind of disappointed in myself. What I really ought to have done is bought more of these. This is good. I don't know where I can buy like more than one of these at a go, because this is actually quite tasty. I got to see if I can like order in like a 6-pack or something, because I can tell you the place I got this, they're quite expensive. YEG Exotic. They've got all sorts of stuff you can't get typically, but they're like $4.50 a piece. So I'd love to try to find some in a better source there. I see 3 inmates escaped from corrections in the past the other day, but they're back in now. Doesn't typically happen with the maximum security folks. Typically, when you see escapes, they're from much lower security. So, and a lot of the time, the escapes are just like somebody was allowed out for a short period, and they just didn't return. So that's a really common way for people to escape, is they just walked away from like minimum security. Cat Yarb, thank you very much for the super chat there. Love your channel. I missed the beginning. What is the drink? This is Dr. Brown's original Celery, which is celery soda with other natural flavors. It is not what I would expect to be good, but it's actually quite good. I quite like it. All right, so I'm going to have to see if I can order this in, but let's look at some cases, because we got a bunch of stuff going on, and some of the cases we're going to talk about have to wait until after the 2-hour mark, because there's some messed up stuff, and for that, I am thinking of the lawsuit against Giuliani. That one's got to wait for a bit. So let's look at one that's a little more funny, because yeah. All right, let's start with this one. There's a lot going on this week. So this is Afro Man. Afro Man is so everybody knows hopefully what this case is. Oh, and I see this would actually be really good. Ruckle of the Bailey, you just need some hot wings to go with that celery soda. That would actually be really amazing. And Nicholas, I will get to your super chat. I will. Okay, let's get to it now. Nicholas Staro's Trial Watch. That's 20. I think that's Swedish krona. $7 Scotch. Pants for a prison. Nice. And it's not the libs' fault. Then why are premiers and police chiefs saying it's because of Bill C-75? Largely because politicians are full of crap. Bill C-75 didn't really do much other than just put into the law what was already the law because of the Supreme Court. So what happened is the Supreme Court came out with some rulings that said, here's what the law is. And the liberals kind of just said, okay, we'll put that in the criminal code then. Which, yeah. So if you haven't been following Afro Man, Afro Man is a musician. He's done a number of songs. He is what is it? He got famous for Because I Got High. He then also did songs about a police raid because the police raided his house looking for drugs, and he did a couple of songs mocking it. He started selling merch mocking them online, and the police got real upset. Also, I'm just going to note this. I saw Boss Attorney Bree's wedding photos, and they're so cute. Oh, my God. Boss Attorney Bree, if you're not following her Twitter, that's where those wedding photos are. They're pretty awesome. And the other thing is I met her and her guy. Her guy's got style. So he looks good in those wedding photos. So does she, of course. But I mean, the guy can wear the hell out of a suit. It's a talent that I don't have. So I kind of appreciate that. All right. So anyway, the police wanted to sue Mr. Foreman, Afro Man. And we reviewed their initial complaint, and I had a summary of it, and that summary I don't have a good video for. I should probably get one. Maybe the best summary is from my break overlay. This is kind of describing what I thought of their lawsuit in the first place. Yeah. So they're now coming back and they want to amend the lawsuit. Oh, yes. And I forgot that he was accused of kidnapping. That's why they had to look in the suit jackets and the CD cases. Yeah, they could have hit an entire person in those. So, all right. And I see people saying Amazon has the Cellray. I'll have to check that out. So now they're looking to amend and supplement this complaint as follows. Let's see. Do they do any better the second time around? So they're just listing all of the plaintiffs to start. All right. Hungry Hustler Records. There we go. Media Access. John Doe. They sue a bunch of John Does. Factual background. Defendant Joseph Edgar Foreman. Foreman is a creator, producer, and performer of music and videos who's known by the stage and commercial name Afro Man. I don't think anyone's going to dispute that. That one seems pretty straightforward. That's the kind of thing where it's like, we admit paragraph 1. In addition to music and music videos, Foreman markets and sells a variety of products, which include beer, marijuana, t-shirts, and other merchandise. None of this is controversial so far, but and he sells his products online. All right. So on August 21st, they conducted a search pursuant to a lawfully issued search warrant. I'm kind of curious as to the basis for the warrant, honestly. He was not present at the time of the search, but his wife was in the home, observed the search, and recorded portions of the search on her camera phone, including the faces and bodies of many of the law enforcement officers involved. Now, one of the things that you're going to see is you'll probably see officers trying to shut down people filming going on. So you'll probably try to see people saying, like, you can't film us during this search anymore. This is good stuff. I like this. Foreman's residence was equipped with several security video cameras, which also recorded many portions of the search, including the faces and bodies of many of the law enforcement officers involved. Foreman creates commercial videos with faces and bodies of plaintiffs. So after the search was concluded, Foreman used portions of the recordings of the search from his wife's phone and his surveillance cameras to create music videos about the search. These music videos, by the way, are hilarious. These music videos clearly portray the images, likenesses, and distinctive appearances, personas, of many of the officers involved in the search, including those of all plaintiffs. Foreman created dozens of videos and images of plaintiffs' personas and posted them on various social media platforms, including Facebook, YouTube, Snapchat, TikTok, and Instagram. Thousands of people have viewed Foreman's postings. Again, because they're hilarious. And because they share a valuable message. The valuable message being the police suck in this particular instance. That was that's protected speech. So, Foreman has used and continues to use the videos and photos of the plaintiff's personas for commercial purposes to promote his Afro Man brand, to sell products, to promote his music tours, and to make money from the use of plaintiff's images on videos and other media. Now, here's the thing that is a big issue. None of these are selling because the plaintiffs are known or special or anything else. They're selling because they're hilarious, because he's making fun of them. That's why people are getting into this. So now they have examples. Instagram post containing an image of Foreman wearing a shirt with an image of plaintiff Sean Cooley beside an image of Peter Griffin from The Family Guy. Caption, "Good morning, ladies. What up, fellas? Congratulations to Officer Poundcake. Thank you for getting me to 5.4 million hits on TikTok. I couldn't have done it without you, obviously. Congratulations again. You're famous for all the wrong reasons. As you can see, all my pound cake is gone, officer. Officer Poundcake confiscated my pound cake. He said something happened to his body camera on the way to the evidence room. Lol." Which sounds to me like charter protected speech, right? Or not charter, U.S. constitutional protected speech, right? I mean, that sounds to me like he's mocking the officers for activities they did in their in the course of their function. Now, I see somebody saying that this is kosher. Hey, it's got a K on it, but I think that's for Kentucky. I don't know if it's kosher, but somebody's saying I need to ask Joe if he likes it. All right. Instagram a post containing images of fans holding merchandise that contains images of Cooley. Caption, "Lemon pound cake." Instagram post in which Foreman confirms that OG Afro Man is his official account. And it keeps going. So basically, they're upset that he's mocking Officer Poundcake. And yeah. And I mean, you've got things like, "Good morning, ladies. The hatchback of Adams KKK County set to get my new album, Lemon Pound Cake, September 30th. And they posted a picture of him next to an image of Quasimodo. So they're mocking him again. All right. All of this seems like constitutionally protected free expression, right? So where are they actually getting to, we're going to skip past this because there's a lot of them. Where are they actually getting to the image rights here? Well, they're saying Foreman created, posted, and publicized these and other depictions of plaintiffs' personas for commercial purpose through, in cooperation with, or with the assistance of the other defendants, all of whom knew that the plaintiff's images and identifying characteristics was not authorized by plaintiffs. Well, here's the thing. You don't normally have to ask permission from somebody in order to make fun of them. For example, if I post the official, like the images of Trudeau in, everybody knows the pictures I'm talking about. I'm not going to say the words because then YouTube might get annoyed at me. But everybody, if I post those pictures, Trudeau probably doesn't want those pictures floating around, right? I can see why he would be upset by those images. He might prefer that those be suppressed, but it's not up to him, right? I get to post pictures to mock him without his permission. That's how that works, especially when you are some sort of, when you're acting in a governmental capacity. And apparently Cellray is, in fact, kosher and was at one point called Jewish champagne. Interesting. I'm going to have to get more of this because this is good. I see. Is anyone else hearing a background noise? I hope it's not. I hope it's not my AC. Although there's also people mowing lawns nearby. It's summer. Not a whole lot I can do about that. All right, Foreman defames plaintiffs with false statements. Now we're getting into something. Now we got a defamation claim here. In addition to, and in connection with his use of plaintiffs' personas, he published false and defamatory information about plaintiffs, which he knew to be false, in a malicious and intentional effort to damage their reputations and cause them emotional pain, suffering, humiliation, and embarrassment. Examples of some of Foreman's false and defamatory statements about plaintiffs are the following. So, on or about March 18th, 2023, Foreman published an Instagram post that, amongst other things, stated that plaintiffs stole my money and were criminals camouflaged by law enforcement. That's at least something that's a viable claim. It's not a crazy claim. I don't think it's going to succeed. And the reason why I don't think it's going to succeed is that there was actually an issue with respect to the amount of money he got back versus the amount of money that were seized. So I think he's actually going to have some problems on that, because that could be a viable opinion on that. On or about January 24th, he published an Instagram post that, amongst other things, called plaintiffs the white supremacists operating inside of the Adams County Sheriff Department. That one's getting a little spicier. That one might be a little bit of a problem for Afro Man. We'll have to see. But that one still kind of, yeah. On or about April 6th, Foreman published an Instagram post stating that plaintiff Newland used to do hard drugs, snitched on all his friends. Now he steals money from traffic stops, bogus raids, and the Adams KKK County Sheriff Evidence Room. This one, I hope he... This one, I hope he's actually got some backup for, because at this point, I think that maybe he should have chatted with his lawyers on this. He's getting a little too spicy on this, and these are the sorts of claims that you can have problems with. Now, that said, I don't know, because it could be that Afro Man has a basis for that. And I see Izzy saying, courts have said multiple times white supremacist isn't defamation. Yeah, I mean, this one is, I think, weak. The used to do hard drugs and steals money from traffic stops are places that are getting into a bigger problem. Because that's, those are allegations of crimes, and those I hope he's got something to back up. But we'll just have to see. So now I see people asking, is this actual malice? And I don't know. I don't know if these are public figures in that capacity. The actual standard for what kind of defamation is something that is going to have to be argued. That's going to be an issue in court on that. All right. He posted Instagram posts that say that this person stole my money, that he stole $400 out of the evidence money. Again, I think that one he's got a better argument for, because he's said in the past that he's missing money, right? Now, in various posts, he's also getting himself into potentially some trouble there. Clearly and unambiguously implies with words and images that Lisa Phillips is biologically male, is trans, or is lesbian. That could possibly cause problems as well. He states that the purpose of the search warrant was to permit the sheriff's department to kill me, and the plaintiffs attempted to kill me in front of my kids, came to kill me in front of my children, and the plaintiffs constituted a hit squad to kill me in front of my kids. Again, a little bit too spicy. And this is a good point. It's actual malice because they claim they have a persona with commercial value in other counts. That said, you can argue in the alternative. And what I mean by argue in the alternative is you can say, we think we have a persona that's worth money, and but if you disagree with us, then we were defamed, right? And so you can actually argue the alternatives on that and basically say it's one or the other. And I'm still... Sorry, I've got my tweezers here because I'm still finding slivers from my adventure yesterday. My wife is laughing at me because, of course, she told me not to do it. So I say we started with something light. This is getting dark. It's still kind of funny. I mean, these are just claims So they're saying that these are false statements and injurious to plaintiff's reputation. They have been subjected to ridicule, even in further performance of their official duties by members of the public who have seen some of the described postings. In some instances, it has made it difficult and even more dangerous for plaintiffs to carry out their official duties because of comments made and attitudes expressed to them by members of the public. Now, here's the thing. You've, if you do something that the public doesn't like, you don't have a right to a reputation. You've got a right not to be defamed. And there's going to be a real line on this one as to which this is. So as a result of this, they've been subjected to threats, including death threats by anonymous members of the public. And they say they've suffered damages. Now, here's the thing. I actually think that they may now have a claim in this. Afro Man started out in a great position, and he may have gone too far in his mockery. And so this is going to be an interesting one to follow, because now we've got issues as to whether or not this, he's now created a case for them. So that's going to be real interesting. Now they're also trying to argue that they have commercial value, that they're personas. The plaintiffs are each law enforcement officers in Adams County, Ohio, whose names and personas are known in that community and beyond, both as public servants and private citizens. Plaintiffs' personas are distinct and recognizable within Adams County and the surrounding area, and plaintiffs have built that distinct recognizability through years of public service and private activities and exposure to the public, often at great risk to themselves. I think they're going to have a hard time selling this, right? I think that they're going to have a real difficult time selling this. Where are they going to find somebody who says, like, I knew who these cops were before Afro Man? That'll be tough. And see, hey, where is the hammock? I can't really do the hammock stream and review law. So I'm going to do the hammock thing. I'm probably going to do that on like Thursday or Saturday or something. And I'm going to set up the hammock. I'm going to just have like a chill hangout. We'll just kind of hang out and chat. It might be members only. I haven't decided on that. And I also want to set up a video camera in the backyard so that the dogs can run around and people can see the doggos. That I think would be fun. All right. And yeah, right? People get way too interested in other people's business sometimes. All right. So they say that they each have significant commercial value. I don't know that flies, and that they use their, for commercial purposes. I don't think that makes sense. And the pups, I think people are saying it sounds like the pups agree. I bet the pups do, especially because I'd probably bring a bag of treats out there just to keep them running around. All right. The personas of the plaintiffs were not used by defendants in connection with any news, public affairs, sports broadcast, or political campaign, and their unauthorized use of plaintiffs' personas for commercial purposes was not justified or excused. It's kind of news and public affairs, right? Kind of sounds like that. So yeah. So they're fixing that, or they're trying to fix that to say, yes, we are of value. I don't think those claims are going to survive a motion to dismiss, but we'll see. So in using plaintiffs' personas as alleged herein, defendants have appropriated for their own use and benefit the reputation, prestige, social standing, public interest, and other values of plaintiffs' names and likenesses, which have intrinsic value in contravention of plaintiffs' right to privacy. I, again, don't see this because, he's not using their reputation, prestige, social standing, etc. Because I don't think that the police would be saying that their reputation is as people who are hilarious objects of mockery, right? They're trying to claim like that people are buying this because they're like, oh yeah, I totally want to be, associated with Officer Poundcake. No, it's actually the opposite. It's they're joining in on the making fun of. So false light privacy or publicity. So they're saying that they made statements that were false and they knew to be false, which portrayed plaintiffs in a false light, subjecting them to reputational injury, undue ridicule, embarrassment, mental distress, and danger, and that this would be highly offensive to a reasonable person. I don't think that this argument was out there on the table at the start. And now it seems to me like it might be on the table. Afroman maybe should have kept to a limit on that one. Invasion of privacy, unreasonable publicity given to private lives. So they say this is a restatement. I don't think that this is the private lives which were not of legitimate concern to the public. This, or at least for the portions of the video. However, Afroman may have gone too far on this one as well, as in the sense of talking about the sexual orientation or gender identity of plaintiffs, criminality of family members, etc. Yeah, that might make a claim. That might create an issue. So, and there's additional aspects about defendant's statements that plaintiff stole money, threatened to kill him in front of his children, were sent as a hit squad, white supremacists, criminals, used to do hard drugs, is a snitch, steals money from traffic stops and bogus raids, and stole $400. So all of these. Now, I think that issues like with regards to what he said about them during the raid, I think they're gonna have a real tough time on that. When he starts talking about him stealing money from traffic stops generally, now we're getting out of I have an opinion about what happened to me and into specific, actionable, arguable things about a particular person. Because if you agree that this guy steals money from traffic stops, then not only should he not be a police officer, he should be getting arrested and charged and all of that. That's probably going too far. That's running some real risk. So I think Afroman may have bought himself some trouble on this one that was not really necessary. Now, I'm just going to note, and this is kind of funny here, Bruce Rivers, counsel for defendants Foreman and Hungry Hustler. Bruce Rivers. Anybody know who Bruce Rivers is? Yeah, he's got a YouTube channel. He's got a YouTube channel that's way more successful than mine. So, and I mean, good for him. He started it a lot earlier than I did, and he does great content. This is not, I'm not bashing him on that. I'm just saying he's got a YouTube channel. It is, his lines about like, you need to stop self-snitching is great advice. He's a funny guy. I would love to, Bruce, if you see this, we need to do a video. Call me. Because that would be awesome. Somebody noted it's in this. He's still using an AOL account. That's kind of interesting. So somebody says, "Am I going to be a named defendant soon?" I don't think so. The reason Bruce Rivers isn't a named defendant, he's representing Afroman. He's actually representing Afroman in this. And yeah, he reacted to the music video. Yeah, people were asking, why don't you do a reaction to the music video? Afroman did one. And Afroman is, he's probably in a better position not to get, or sorry, Bruce Rivers is probably in a better position not to get sued by Afro Man, because you're probably not going to sue your own lawyer for copyright infringement. All right. So Equality, thank you for 5 gifted memberships. Much appreciated. Amanda Wagstaff, thank you for the member chat there. Catching up on 2 times speed. Fast Runkle makes me smile. Do I dare listen to that? Jamie Krantz, thank you for 10 gifted memberships. Much appreciated. All right, let's do a swoop. We got a swoop. All right. So lots of stuff is going on. It is crazy. Now, I said that I would do I said I'd do a discussion that I think is a worthwhile discussion on the chicken nugget lawsuit. Chat, are people familiar with the chicken nugget lawsuit? Yes, no, hopefully. So basically the somebody sued McDonald's for their child being burned by a chicken nugget. And everybody in the press was talking about how this is similar to the hot coffee case. Now, if you remember the hot coffee case, that was a case where a woman got served coffee. She spilled it on herself because she didn't have a cup holder. And that coffee burned her quite seriously and, in fact, caused 3rd-degree burns. Now, this that in that case, they were awarded a bunch of money. And the reason why they were awarded that money was because McDonald's knew that their coffee was too hot and was intentionally selling it too hot because it was easier to do. They were selling it too hot because if you've got bad coffee and you serve it real hot, then people don't notice as much. And so there are pictures of that one. I'm not going to share the pictures because the pictures on that one are pretty awful. But the hot coffee case was interesting because the other thing is that the McDonald's hot coffee case actually resulted in McDonald's doing a lot of PR work. After they lost that lawsuit, they basically did a bunch of PR work to convince the public that this was a ridiculous case and that lawsuits had gone too far and that McDonald's was not at fault. McDonald's was innocent. McDonald's was, they were the poor, hard done by victims in this case, which is BS. They sold this line to the public. And it's only now in more modern times that I think that there's a lot of people who actually know more about this. Other things that are worth noting, people have portrayed the woman in the McDonald's suit as if she was looking to get rich quick. But in fact, all she asked for was her medical expenses, her out-of-pocket expenses to be covered. All she wanted is just not to be out money for that. And McDonald's said no and ended up having to pay more than that because the jury was so pissed that they hammered. Oh, and we've got an EDB raid coming in. EDB said to give purple hearts. Awesome. Hello, EDB. Hello, EDB followers. Yeah, and this is very much true. It spawned the American sue for everything perception. It absolutely did. Now I'm out of celery soda, and I am sad. All right. So this case has gotten a lot of comparison to that case. And this case is a little bit different. This case has some different stuff going on in it. And this one is going to be a little more controversial. I see Noe is not drinking a beer yet. I will probably have a beer later. Celery soda. Yep. Yeah, that was celery, Dr. Brown's celery soda. So, all right, let's have a look at this one. This one is, we'll just bring this up here once I can. All right. Felana Holmes and Humberto Carabello Estevez suing Upchurch Foods and McDonald's Corporation. And there is a complaint for money damages and a demand for trial by jury. We're going to have a look at some of this because there's all sorts of issues there. So comes now. God, I hate that line. God, I hate that line so much. Jurisdiction. This is an action for damages in excess of $15,000, which is why, this is important as to venue. And I just want to sort of note how much they're suing for here, because this will be important when we get to it. So general allegations. Let's talk about what the allegations are in the suit here. So OH, that's the child, was a rear seat passenger in a vehicle driven by their mother. Her brother, also a minor, was seated beside her in the rear seat. OH's mother drove her into the restaurant's designated drive-through lane where she placed and paid for an order for, inter alia, a 6-piece chicken McNugget Happy Meal with milk and a toy from the Lion King. Cool. Now, the older brother apparently didn't get a McNugget meal, because when he gets a McNugget meal, apparently he can't be trusted with sauces. This is what the mom had said, is that he will spill the sauces all over the car. So he got a burger. Just fun fact. There's not a lot of fun facts in this one, but I guess that's the closest we're going to come. All right. So these are the allegations. The chicken McNuggets inside of that Happy Meal were unreasonable and dangerously hot in terms of temperature and caused OH's skin and flesh around her thighs to burn. As a direct and proximate cause of the unreasonably and dangerously hot chicken McNuggets, OH, who is only 4 years old, is now disfigured and scarred. The picture did not come through. I didn't censor this. I didn't block this out. This is how it was on the record pages. Now, what do you call it? There are pictures out there. She sustained a pretty bad burn on basically a McNugget-sized area of skin. All right. So count one, strict liability. They're saying the restaurant was engaged in the selling or otherwise introducing in the stream of commerce food and beverage products intended for human handling and consumption, including chicken McNuggets, as well as toys intended to attract and/or entertain children. I think that you can successfully argue that a Happy Meal is intended for kids. I don't think I'm going to see a lot of people in the chat going, "What the hell, Runkle? You're full of crap on that." And I see people saying disfigured. Yeah, she's got like a nugget shape burned into her skin. So, yeah, it's unfortunate. So basically, they're saying that they knew or should have known that they'd be handled by OH and her mother in an ordinary manner, including that those chicken McNuggets would make contact with with OH and/or her mother's skin. In fact, I don't know about you guys, but I typically handle chicken McNuggets with my skin. I usually just grab one, dip it in the sauce, and then put it in my face. That's pretty common, right? I've never gone through the drive-thru and been like, yes, can I get 6 McNuggets and a knife and fork? Right? Okay. So, that said, I've gotten nuggets that were hot. Sometimes they're coming just out of the line and so forth. And, sometimes you bite into one, you're like, ooh, that's too hot. I'm going to leave that for a bit. Right? All right. So they say knew or should have known that the chicken McNuggets would not reasonably be tested for temperature separate and apart from the typical and ordinary methods used by the general public under similar circumstances, e.g. a customer physically touching them, making contact with their human skin. Basically, what they're saying here is that people don't bring a thermometer to the McDonald's to measure the temperature of their nuggets. Now, I'm just going to note, when this story broke, I went to McDonald's and I bought some nuggets. And I brought a thermometer with me. And I measured them because I'm a weirdo. But, yeah. So the allegations say knew or, should have known that they were unreasonably and dangerously high in temperature such that they were not fit for human handling with bare skin by their intended customer. And, packaged in a Happy Meal container designed and intended to be attractive. So basically they're saying these things were too hot. This is the allegations, right? They're saying that these are, too hot. And good God, they're not still in there, are they? No, I ate them. They were good. And I had a craving. They were good. All right. So had to prepare food in a reasonably safe manner, including that such items were safe for ordinary handling. So the allegations are breach of duties by failing to provide training on making sure the oil within fryers was not too high, failing to supervise its employees, servants, agents to make sure they maintain the proper temperature of the oil, failing to provide adequate training on how to check the temperature of chicken McNuggets once they were removed from a fryer, adequate policies, all of this stuff. Now, I'm just going to talk a little bit about deep frying here, because this claim, they don't really understand how deep frying works. Deep frying is supposed to be done with very hot oil, and the heat of the oil is basically determined in part by what kind of food you're looking at doing, because you don't want to burn the food, but you want the oil to be quite hot. And the reason why is because you're deep frying things that are moist. I know everyone hates that word, and there's people who are upset with me and so forth. So the reason why they're so hot, I own a deep fryer. And I'm careful with the deep fryer because I know that I could really get myself in trouble if I, spilled oil on myself. But if you deep fry at a temperature that is too low, what you end up with is a couple of things. First of all, you end up with a disgusting meal because if you cook something at a temperature that's too low, the oil soaks all the way through your food and it tastes gross. The next thing is that you end up with a dangerous meal because it's actually a situation where where you can actually get hot oil, and so paradoxically, you can actually get hotter food coming out of the deep fryer if your oil is not hot enough than if it's at the right temperature. Because when it's at the right temperature, when you put the food in it, when you put like a French fry in it, the water within it turns to steam and starts steaming out of it. That's why when you put food into a deep fryer, you get all those bubbles. That's water vapor. That's not air. Like your potatoes aren't breathing under oil when you put them in there. It's venting that water. And so when you pull it out, you should actually have very little oil permeation because that water steaming out actually keeps the oil from penetrating into the food. There should be very little oil in the food. So this, I think, reflects a failure to understand how deep frying works. So I'm just going to note that here. There shouldn't be oil on, your deep fried foods should not be oily. And quite frankly, I've never gotten an oily nugget from a McDonald's. So now they've got a bunch of claims here and so forth, and they're asking for an amount in excess of $15,000. Do they give us the actual total amount here? Just in excess of $15,000. All right. Now, there are a bunch of discussions about this online. And I can tell you that those discussions do not go into a huge amount of detail. But there's actually a ton of information about this that is available for the having. And what I mean by that is that I went on Pacer and I pulled a document that's going to be expensive. And what I mean by that is that Pacer charges you by the page, and this is 250 pages. So what we have here is the appendix to the plaintiff's motion for partial summary judgment. What does that mean? It means that the plaintiffs in this case asked for the court to just rule in their favor, right? To just say, hey, we should give this to you. And now what I want to have you notice here is just how many documents we have. We got a lot of documents. Now, we don't actually get all these pages because I think a bunch of them were edited out because it's protection orders and so forth. But we can get a bunch of details. So one of the questions that people were asking for on all of this was what temperature were these nuggets being served at? And that's a really good question that we can actually answer here. So let's have a look. This is from the depositions. All right, so question, do you know what temperature those hot cabinets store the food items that are put in the trays within them? The products in the cabinet is going from around 145 to 160, 66 degrees Fahrenheit. Yes. What is the temperature of the trays in the hot cabinets that store chicken McNuggets? The temperature of the chicken McNuggets? No, ma'am. The temperature of that tray or the area within the hot cabinet that stores chicken McNuggets after they've been cooked and placed there. It's the same from 145 to 166, 67, but not the trays, the food. The trays we can pull and it's not hot. All right, so let me try and step back a little. Who determines what temperature the hot food tray storage device is set to? As I say, that is already automatically. I don't know who set up that. Do you as a manager know how to change the temperature on that device? No. How do you know whether or not that device is functioning properly with respect to the temperature that it is storing food? Answer, because we check the temperature all the time and it's too hot, with the lights on. What do you mean you check the temperature all the time? We have the thermometer that's specific for food that we, at least 3 times a day, we check. When you're referencing a thermometer, are you referencing a device that you stick inside of a cooked food item to determine the temperature of that food item? Yes. Do you know the name of that device or who makes it? No. Who gives it to you in the store? It was in the store already. We just learned how to measure. And where's that temperature device stored and where is it located within the restaurant? At the office. Whose office? The GM's office at the store. How many of those temperature devices do you keep? It's 1. So, and they say they check it 3 times per shift. Why can't they change the temperature? Why can't they change, why is that thing designed to not let because McDonald's is a franchise, right? And franchises, you give up certain amounts of control. You have to do things that are per standard. And in this case, the temperatures are not just because it's a comfortable serving temperature. The temperatures are also because you have to make sure that you're not serving food that's gotten too cold. The key thing there is really the too cold aspect, because you don't want these things to get, let's say you got a McNugget that's going to sit there for, 45 minutes. And it probably shouldn't sit there for 45 minutes, but let's say it's going to sit there for 45 minutes. If its temperature drops too far, then bacteria can grow in it. The old line is you have to keep your hot foods hot and your cold foods cold. You never want to keep any food warm. So that's why these things are in these trays, to keep them at a particular temperature, is to make sure that when you get to the drive-thru, that you're not going to get a McNugget that's going to kill you. Right? Nobody wants to get a murder McNugget. That's not what people are paying for. All right. So, this manager is saying that that's the temperature they look at. Let's pull up a reference here. So this is another sort of important aspect here. What is the highest temperature that you can remember seeing a Chicken McNugget when you tested it? 202. And that would again be Fahrenheit. Now, if you're wondering, if you're wondering why a McNugget might be at 202, well, that's pretty close to boiling, right? And so once you put that McNugget into a hot oil and it's venting that, that steam, it's because it's at the boiling temperature. So that would be a McNugget that had just been removed from the fry basket, might come out pretty close to boiling. Now, I'm just going to tell you, those temperatures will plummet fast. That'll come down to the warming temperature pretty quick, because the McNugget is going to have it's got a lot of surface area. It's pretty small. And I'll note here, the oil is running 350 degrees, but you're not going to get the McNugget up to 350 degrees unless there's two ways you can get that McNugget up to 350 degrees. So the first method is if you took the oil and you had room temperature oil, you dunked the McNugget in the room temperature oil, and then you heated it to 350 degrees. Then you'd have an oil sponge McNugget, which would taste disgusting, and you might be able to get it to 350 degrees. The other way to get it to 350 degrees is if you boil out all of the water. And I can tell you that the water, because water boils at, a little over 200 Fahrenheit, boils at 100 Celsius. And you're not going to be able to get it above that temperature until you get the water out. And so once the water is out, what's going to happen with that McNugget? It's going to be blackened. It's going to be crunchy. And trust me, no one's going to eat that McNugget. Like, that McNugget is only useful for being a building material at that point. Nobody would serve the McNugget at that point, right? You put the McNuggets in the tray, you see that they're like blackened and crispy. No one's going to serve it. So it's never going to get up to oil temperature. It just isn't. That's sort of how this goes. The people who've been saying that this kid was burned by the oil, I don't think that's correct. Especially because, let's say you have oil on the surface of the McNugget. Well, then you put it into a cardboard box. And what happens to it? That oil's going to, soak through. I'm just going to note here that I got a cardboard box that had McNuggets. And I just kind of want you guys to see this, because there's not a lot of oil staining on that. There's very, very little oil staining. I think I'm done with this McNugget box. I don't think I need it anymore. McNuggets are not typically coming out as oily. All right. So that's our sort of starting point on this, is just, in terms of McNugget temperatures. Okay. So, I know that's really exciting stuff, and everyone's like, all right, Runkle, why are you telling us all this stuff about McNuggets? Well, let's talk about how this case went down. I see. Question: what sauce did you get? I always get the barbecue sauce. All right. So let's talk about how this happens. And this is with prolonged exposure, the temp required to burn is actually really low. Yeah, that's exactly it. Because when we pull this up, this is the deposition of Mom. This is Mom, right? Mom was in the car. She testifies to what happens. And so, she says, born in Michigan. We don't really care about all of that. We're going to skip forward to, where this actually goes down. Scrolling along here. Yeah, there's a lot of discussion here. All right. So now there's notes about she had learning disabilities. This child had some learning disabilities. Some people had said, oh, this kid's got, autism. that this kid was unable to do anything because of the autism. I don't think the autism plays any role in this. I don't see any major likelihood on that. So they're still talking about like how's virtual learning and so forth. So, all right. So I just gotten home from work and I picked them up on my way home from work. And that particular day, they wanted McDonald's, as kids do. McDonald's is directly across from the martial arts school. My house is maybe a block away from there. So I decided to take them home, see if my husband and son wanted something to eat as well. When we got home, they changed their clothes and I got, their order for my husband and son, headed back to the McDonald's, and I took my kids with me, as one does, right? Parents, a lot of people have been like, well, why would you have your kids there? Well, because they're parents. Of course you do. We got to McDonald's. I ordered, 2 chicken McNugget meals, and I believe my son wanted a double cheeseburger meal. And then me and my husband got like 20 nuggets and 2 drinks, so it was a sizable order. Now, this sizable order thing might mean that these nuggets are coming out a little hot, because when you order a ton of nuggets, you're probably getting some fresh nuggets. But they don't. We'll have to see if they say that they waited for the nuggets, right? So we pay, we go to the second window, and the young lady's handing me the kids' meal, and also my son had wanted a cheeseburger. So I'm handing OVC her kids' meal with the chicken nuggets, and then I give my son, I give him the cheeseburger, and then I believe I gave him the nugget box, but it was next to him because he likes sauce, and I don't let him eat sauce in the car. No sauce in the car. You get nuggets, but not now. And the rest of the order, I put it away in the seat next to me. So I'm pulling away out of the drive-thru. I hear OVC start to yell. But by the time I make it to the street, it's a full-blown scream. Note that, right? It starts out as a yell and then turns into a scream. It's getting louder over time, right? It's getting louder over time. I turn around and she dropped the nugget in her lap. So I'm trying to drive and knock them out of her lap as I'm going down the street. So as soon as I'm able, I pulled over, I run to the back seat of the car, and I got out the nugget that I could see, and then I pulled off her seatbelt. And then right there on the seatbelt across the lap, there was a chicken nugget that was stuck that I could not reach. Even Mom, when she's pulled over at the side of the road, like, helping this, she can't reach this chicken nugget because it's gotten wedged in there, right? As I'm taking the nugget off the skin, it's falling apart. We'll skip over that. She was injured. She's screaming. She's yelling. I'm trying to calm her down. I'm calling my husband. Please go to the store and get her something for her legs. And so they put the seatbelt back on and rush home. And she's screaming. Now, I don't know when the filming starts on this because she was filming. But I see child yells and she proceeds to drive into the street. She initially probably didn't know what was going on, right? She probably didn't right away know what was happening. And so then there was injuries. They go to the emergency room. Now this is interesting. What kind of car seats? Are they the ones that go around the shoulders and then they buckle in the middle? Yes, OVC is a 4-point harness. So it goes over her shoulders and across her lap. And he's in a booster seat. At the time, was OVC capable of opening the buckle to her car seat? No. No, she was not. All right. And she says that the boxes came first because she was in the back seat getting the Happy Meal boxes. And she passed them back to the daughter. So this tells us a bunch of things, right? People have said, oh, it's, the autism and so forth. It's not the autism. It's that she's stuck in a car seat that she can't open, that she's unable to manage, that this kid, once the kid gets a nugget in there. So, I mean, when we look at temperatures, right, who's had the experience of you get you get some soup and you cook it in the microwave, right? And then you pull that soup out and you test it with your hands and you go, okay, that's not too hot. And then you take that bowl of soup and you're going to walk it into a room where you're going to eat it. And as you do, you're like, oh my God, this is too hot. You have to set it down, right? It's because as that temperature as that heat sort of transfers, what didn't initially feel like too hot can pretty quickly become too hot. I don't think that these nuggets were too hot to eat at the time. What I think, though, is that these nuggets were too hot to press hard against skin. Because I can tell you, when I got those nuggets, I had no problem eating them. They were just fine. But I also took one of those nuggets and just tested by pressing it up against the back of my hand. And I went, holy crap, this hurts. I had to stop. This to me, now I should note, the jury found that McDonald's was liable in this case. McDonald's is going to have to pay. But I personally kind of think that that this is a situation. I don't think McDonald's, based on what we've seen here, it doesn't look like McDonald's actually did anything wrong. And I don't think mom did anything wrong, right? Because mom, parents hand food to their kids all the time, right? This is super common. It's just a combination of bad factors, right? Sometimes things happen that aren't necessarily anybody's fault. Let's say I'm cooking some bacon on the stove, right? I've got bacon going. And then I go and, turns out Potter's sicked up on the floor and I didn't see it. And I slip in that and I fall and I hit my head and I pass out for a while, but then the bacon catches fire and the house burns down and I'm seriously injured. I don't think that I can sue the bacon company, like the bacon maker in that case. It's just, a series of bad circumstances that collectively lead to some trouble. And that is, that's a problem. So why do I suspect, and again, I haven't watched this whole trial. Why do I suspect that McDonald's got held? Because McDonald's is going to have to pay on this one. They're going to have to pay a ton of money, probably. Probably their medical bills. I don't know how much that is, but there may be additional costs and so forth. I don't know why, for certain why they had to pay, or why they're having to pay, but I suspect that it's because there was video footage of this child screaming, and I don't know where that came from. There was no questions asked as to when the filming got started, but I suspect it's the jurors hearing, this child, and you hear a child in pain, and you just want to protect the kid, right? You want to stand up and help that child. And I suspect that they went, somebody's got to pay, and McDonald's is here. So McDonald's is going to pay. That's my suspicion. So, some people have said, oh, Rick, Runkle, are you on Team McDonald's? Kind of. I'm just kind of on this thing of, I think that this is a situation where I don't know that anybody did anything wrong. It's not mom's fault. It's not McDonald's fault. It's just, this is one of those cases. Somebody's saying, can McDonald's appeal? They can. I don't know if they'll be successful because it's hard to appeal a jury verdict on the facts. So yeah, I see, they only lived a block away, mom said. Mom should have waited to give them the food until they got home. Even if the kids start screaming for it, they'll get it in a couple of minutes. I mean, parents give their kids food all the time, right? I don't think anybody was expecting that this was going to be a big deal, right? Nobody was like, oh yeah, this kid's totally going to get injured by this. So, what about faulty car seat structure? I don't think it was faulty, right? The car seat manufacturer certainly didn't have any way to anticipate that there was going to be, hot meat pressed up against somebody's, So I don't know. This one to me is I I think it's a real unfortunate case. I don't think that there's a good answer to it, other than just um, we we can have sympathy for this kid, right? So I see. Is this the same case that had underage kids working fryers? Different case. That's a um, different lawsuit on that one. All right. Now I'm going to step away for a second because I got somebody sent me a new hot sauce, and I said I would try that on stream. So I'm going to try that. I've thought about doing like a, other lawyers do like a drink for super chats, which isn't really my style, but I've thought about doing a take a pull of hot sauce for super chats. So maybe I'll start that up at some point. But I'm going to hit the swoop. I'm going to hit the brief break. I'm going to go get the hot sauce and we'll try that out. And then we've got more cases to cover. So I'll just be right back, folks. All right. Hopefully everyone can hear me. I said I'd be right back. I didn't plan to take long, so I am back. All right. I wasn't actually doing what what that particular stepping away message was implying, but somebody sent me this. So it's Ashburn Sauce Company Carolina Reaper hot sauce. Now I'm wondering if the Ashburn is meant to be pronounced in a particularly different way, but so just looking at the sauce, I see that it's got little bits of seeds floating in it, which is a good sign. Suggests that an actual pepper went into this. I'm just getting out the pocket knife here to crack this open. Oh, right. People are saying make the screen bigger. Embiggen. Ashburn, Carolina Reaper hot sauce. There we go. All right. I've ground Carolina Reaper homegrown and dehydrated. Would you try it if I send you some? I absolutely would. I actually I have some ground Carolina Reaper and I throw it into a bunch of stuff. I mostly can throw it in when I'm cooking for me because if I'm what is it? If I'm cooking for my wife, she has very different spice tolerances. And I see somebody saying, yeah, that's kind of. I'm wondering if that's a pun. So, and Lori Lenny is saying, please always read the ingredients. Vinegar, so it's a vinegar base. Aged peppers, water, xanthan gum, lemon juice, Carolina Reaper mash, hickory smoke, and spices. All right. Let us give this a try. I'm just going to put a little bit. So it's quite smoky, which I like. It's good. It's not as spicy as some of my other sauces. I'm just adding a bit more. So it's got that vinegar bite to it. It's not too heavy on the vinegar. Somebody's asking, did I shake it well? Yes, I did. No, this is a good sauce. I like this sauce. It's sort of smoke heavy. The Carolina Reapers are kind of sweeter, so it's a very pleasant taste in that regard. This I don't think is going to kill me at all. I could take a pull on this one, no problem. But it's a good one. So I like this hot sauce. I'm going to use it on stuff. Somebody was asking, are there sauces that are too hot for me? There are, and mostly it's that some of the sauces are just too, they're spicier than I sort of know what to do with, in the sense that they're a little spicier than you might want. And like the last dab, I found this to be spicy and not very flavorful. Whereas this is a lot more flavorful than some of the spicier sauces. So and I see people saying wash your hands before you touch your eyes. We'll see how that goes. Drip it directly into your mouth. Okay, we'll see how this goes. Not bad at all. Not bad at all. The vinegar makes it a little harder to just take a sip of, but because the vinegar is got that sour aspect. All right. Yeah. Let's have a drink. So grapefruit. It's a very nice sort of summer drink there. Ooh, this I love. We used to do shots of hot sauce and oysters when in our 20s. I love good. I love good oysters. What would I use it on as far as food goes? Oysters would be fantastic for that. I could see this would also go really well in like a stew or a chili or a soup. I think that like directly on chicken would be good. It's a little runnier than some of the other hot sauces. It's not as thick, but I think it would be good on lots of things. I've got some chicken in the fridge, like some. My wife and I bought like a roasted chicken. I'm probably gonna smear it all over that. So, all right, and the last dab, Runkle. Do you watch First We Feast Hot Ones? Yes. The reason why I have the last dab is that Rob and I did that as a did the Hot Ones challenge as my on my birthday. So I'm probably going to try that. There's another Hot Ones challenge out, so I'm probably going to try that in a bit. Worst hot sauce you've ever had? I don't know. There's some really bad ones. Some of them, especially the ones that use extract, some of them can taste quite unpleasant. I'm just trying to think of the worst. Worst is tough because when they're really bad, I tend to just be like, yeah, we're not doing that. We're gonna move on. Now, I don't see Rob in the chat, or I would try to drag him out here because I have a nitro gummy bear. But Rob also got one of these, so he needs to try it at the same time. I also got a box of these. Dr. Fire Blast Balls. So, yeah. Oh, this is a good idea. I like this idea. When is your charity stream? The Hot Ones Challenge 2.0 would be good for that. Yes, that's actually a good idea for that. So that would be fantastic. How about the one with banana? Yeah, that was pretty bad. I'm not a big fan of some of the really sweet sauces, but some of them can be some of them can be better. So, speaking of oysters and your love of them, how long would it take you to eat your weight in oysters? I don't know, but I kind of want to find out. That sounds like fun. So, Dr. Fire. I'm sitting here trying to use my teeth, and then I'm like, oh, right, that's why I actually have a pocket knife, is to open packages and so forth. So let's do that. All right, so chat, if I die, well, I'm afraid I didn't leave anything to you guys in my will. So it's blast balls are bad. You can't chew them or swallow them. You have to let them dissolve. I will keep that in mind. All right. And I see here, I did actually chew it a little bit. It's not that bad. This is actually so far pretty good, but I get that it could turn into something a little worse over time. All right. Let us move on and look at another fun case, because there have been so many things that have been going on here. It's a little nuts as to what all has been happening. All right, so let me just put one thing away and put another thing up. Let's talk about Edmonton and ethics. Two things that two great tastes together at last. All right. Nobody can read this. All right. Edmonton police chief attended UCP T-Rex Derby fundraiser. Okay. So, T-Rex Derby is, you might be wondering what that's about. So apparently, MLAs dress up in T-Rex costumes, and then race on a horse track. So there's some video on this. Okay, so that is ridiculous. But this they do as a fundraiser for charity. Or not for charity. They do this for as a political fundraiser. Now, what's the problem? Well, the police chief of Edmonton went to this fundraiser. And maybe the police chief shouldn't be going to a fundraiser. That's him there in the middle. Maybe he shouldn't be going to a fundraiser for a political party. I kind of feel like that's a bit of an issue. Now, guys, he's got a defense. He says, you know what? I didn't buy a ticket, and I didn't know it was a fundraiser. Well, if he didn't know it was a fundraiser, that's a problem, because this guy's the chief of police, right? We expect the chief of police to be able to have some ability to, like, figure things out, maybe solve some problems. Like, was this guy ever a detective? Should he not be able to detect where he is? I feel like that is a thing. Now, this is a good point. We got people asking. Am I the only one dumb enough to ask, what's a UCP MLA? UCP is one of the political parties. Oh, I'm being told I should do a swoop. I owe you guys a swoop. All right. So UCP is the United Conservative Party here in Alberta. And MLA is a politician. So, they're elected to public office. So why is this guy going to a campaign event for one of the political parties? He should be staying neutral. And he says he didn't know that it was he didn't know that it was a political event. Well, he's the police chief. He should be known. All right. So, tickets apparently ranged in cost from $100 for just an entry ticket to $3,000 if you want to go to the Ralph Klein VIP suite. I don't know what the heck that is. All right. But you might be saying, how'd he get there if he didn't buy a ticket? Well, his ticket was purchased for him, apparently, by somebody else. He came there as a guest. Who did he come with as a guest? Well, Vince Morelli is who he came as a guest with. Now, Morelli is the president of a company called SafeTrax GPS. What does SafeTrax GPS do? Well, they make ankle tracking bracelets. You know, when you get on your when you get released on bail, sometimes people have like an ankle tracker. But in Canada, we very rarely use ankle trackers. Very uncommon. But the Alberta government the UCP has made a campaign promise. They have made a promise, if they're elected, that they're going to require people who are out on bail to have ankle bracelets. So they're making this promise to the public that they're going to require ankle bracelets. And the ankle bracelet company, is bringing the police station, or police chief, over to this campaign event. Does that seem, what's the word for that? Yeah, this feels sketchy AF. So I'm not super happy about this. And let's talk a little bit about the ankle bracelet proposal. So Alberta wants to require these ankle bracelets. They haven't said if it's going to be for everybody or some people or what, but you got to know how much an ankle bracelet costs. One of the reasons why most people can't, most people who commit crimes don't have a whole lot of money. And ankle bracelets cost a ton. The installation costs money. Getting them removed costs money. And they charge somewhere like, what is it? $600, $800 a month. If you want to, to have it on. That's paid for by the person on bail. So all of this ends up being incredibly expensive. And it creates a real tier system. Now it creates a system where if you've got money, you can you're going to be more likely to get out because you can afford the ankle bracelet. Whereas somebody who has no money, somebody who's poor, might not be able to get the ankle bracelet, might not be able to get release as a result. It's freaking insane what we're talking about here. Now I see, they're saying some courts in the U.S. pay for it for the person. Well, if this is going from government funding, then that's an even bigger concern, right? But the other thing that's going to be a big problem is they're going to be telling the courts. Now, keep in mind, the province has no authority over criminal law. They're going to be telling the courts that they have to impose these conditions. And I think that the courts are going to say, nah, we're not doing that. This is going to be a little ridiculous. Some people are like, Runkle, you're a conservative. And it's like, no, I'm not a conservative. I just think that government should not be stupid. And so sometimes that has me favoring the conservative proposal on something. Sometimes that has me favoring the left proposal on something. In this case, what the UCP, the Conservative Party, is suggesting is dumb. It's real dumb. So, I'm not a big fan of it. I got to say, these things are tasty. I will eat more of these, but not on stream because I realized that having something in my mouth while I'm on stream was probably not the greatest of greatest of life choices. I was sitting there trying not to be too, so yeah, I'm not happy with this. I think that this is real sketchy, and we'll just have to see. So, but I mean, it gets messed up when you get a system where some people who are where people who are wealthy and end up getting released, and people who are poor end up getting detained. So, and I see if no ankle monitors, do they keep people in jail longer or just bail with no monitor? That'll be a real question. And Half Irish noting NDP is far worse. I don't endorse political. Um, I don't endorse political candidates typically because basically they all suck. I've said on Twitter, I said basically I never get what I want in an election, which is that all of the candidates get eaten by bears. So I don't get what I like in elections, but yeah, it just asking government to not be stupid. You have a better chance of getting moon real estate. Isn't that the truth? All right, let's do a swoop. All right. I've got to catch up on some super chats here. Google Dr. Brown's Cell Ray in many places where you can buy in quantity. I will check that out. I thought reading legal stuff is boring. I need to sleep. It's over 3 a.m. Maybe if you spoke more slowly, it'd be boring, but you're not. Thank you. You are more like funny. What do we talk about next? Next up, I think we're going to talk about a plane crash. Nuggets, Laura M. Nuggets and a child meal should never have been that hot. I think McDonald's should pay. There are problems. I mean, there's a certain sort of minimum temperature that they must get to, because they got to be at least a certain amount of temperature. And if they're not that temperature, then they're not safe to serve. So, all right. Next one. Pacer Fund Change Jar contribution. Thank you very much, Al Fliggins. Much appreciated. Lisa Dury, thank you very much for the YouTube membership. Much appreciated. Ohio Palm Mom for your Pacer Fund. Great content as always. Much appreciated. Equality, thank you for the 550 there. My only problem with this case is the mom filming while her daughter's obviously in pain. I don't like being mean to other parents, but it bugs me. It bugs me too. And unfortunately, we don't have a whole lot of details from the documents as to when that got filed and when it didn't. So that's a question. I don't know when the filming started. I don't know what was going on there. So, all right. I see. Runkle, what do you have against bears to punish them by feeding politicians to them? Especially since we have AI-controlled wood chippers. I mean, bears will eat like they'll eat, dead things. They'll eat garbage. Yeah. So, all right. So, next one up, Vanessa Ellison. Thank you very much for the YouTube membership. Much appreciated. All right. So this is a weird story, the one we're going to cover next, because it's yet another example of how to get yourself in serious trouble on social media. Lots of people are doing videos out there that are like, it's just a prank, bro, just a prank. And a bunch of those, I watch them and I'm like, oh no, that's a serious criminal offense. At least it would be in Canada. So you've got, what do you call it? In Canada, I saw one that was actually filmed. It was quite clearly done in Canada. Oh, I'm seeing somebody wants the swoop. All right. So, like one of them I saw that was clearly filmed in Canada. They had people doing just a prank with the whole thing of, there was that trend of people dressing up like clowns. And I don't know if you guys saw that, where they would dress up like clowns and then, chase after somebody with like a hatchet or something. And yeah. So what is it? I'm seeing check Twitter DMs. I don't know what I'm supposed to be seeing in Twitter DMs. So, oh, there we go. Froggy Girl, thank you for 5 gifted memberships. It looks like we're having some trouble getting communication there, so hopefully we didn't miss any there. Just responding to something there, just because stuff is chaos, and because I have attention deficit, and that is a shiny thing. All right. So, yeah, I see people saying Rob would have hated that. Yep. So, you had people dressing up like clowns and chasing after somebody with like a foam axe or whatever. And that in Canada, you'd probably have an assault with a weapon. Yeah, the clowns, the stage thing where people were in a parking garage while somebody killed a guy with a hammer, then chased random people. The scary clown prank. I saw several videos of that where you'd have somebody, and these ones were clearly filmed in the States, where somebody would be like, we're a scary clown. And the guy's like, I got a gun. And they're like, whoa, it's just a prank. The one that I saw that I thought was great, I wish I still had that video, just so that I could do a reaction to it, is guys like, I'm the scary clown. And the guy's like, I got a gun. And the guy's like, whoa, it's a prank. And he's like, cool, prank, great, keep back. And the guy's like, no, man, I'm just gonna. And he's like, no, you go back, you back up. And I'm just like, yep, somebody's gonna get their fool ass shot. And you know what? I would like, it'd be an easy case to defend. Somebody's dressed up in a clown mask, yelling, crazy noises, and the guy who they're chasing with that pulls a gun and puts 2 in them. It's like, oh, right. It turns out it was just a prank for YouTube. But your goal was to make this person in fear of their life. And they were. And so they defended themselves. And y'all get to get buried. Like, that is, yeah. Clown around, find out. Yep. There's another dumb prank where people will run up behind a person shopping at Target and put a bucket on their head. Caused a woman here to get a seizure. Yeah. A lot of these pranks are basically just, we assaulted a random stranger. So, but this one is even worse in terms of the, in terms of the criminal aspects. Oh, I've got the wrong screen up. Let's pull up the right screen. All right. And here we go. All right. So this is the case of United States of America and Trevor Daniel Jacob. Now, keep in mind, United States of America has tremendous, they've got a bigger budget than you do, right? So plea agreement for defendant Trevor Daniel Jacob. He's pleading guilty to this. Now, this starts with a YouTube video. This YouTube video involves him being in a plane and saying, hey, I'm having some plane trouble. I gotta bail out. And he bails out of this plane. Well, people had some questions. They were pretty suspicious about this one. And it's not the USA suing, it's the USA charging him. This is a guy who's facing, serious charges on this. So this constitutes the plea agreement between Trevor Daniel Jacob, the defendant, and the United States Attorney's Office for the Central District of California. So defendant agrees to give up the right to indictment by a grand jury and at the earliest opportunity plead guilty, etc., 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 with the following facts. Not contest facts agreed to in this agreement. Abide by all agreements regarding sentencing contained in this agreement, and so forth. All right, so he is in a lot of trouble on this one. USAO agrees to, recommend recommend that the defendant be sentenced to a term of imprisonment no higher than the low end of the applicable sentencing guidelines range, provided that the offense level used by the court to determine that range is 15 or higher, and provided that the court does not depart downward in offense level or criminal history category. So basically they're saying, we'll argue for more if the guy has to pay more, but or if the court's going to give less, we'll argue for more. But otherwise, yeah. People are saying, how many minutes before spicy time? We are 10 minutes to spicy time. All right. So, defendant understands that for defendant to be guilty of the crime charged in the single count information, that is destruction and concealment of tangible object with intent to obstruct federal investigation, in violation of Title 18, United States Code, Section 1519, the following must be true. 1. Defendant knowingly altered, destroyed, concealed, or falsified a tangible object. And 2, the defendant acted with the intent to impede, obstruct, or influence an actual or contemplated investigation of a matter within the jurisdiction of any department or agency of the United States. What is the tangible object here? It is the aircraft. It's the entire airplane that he was flying in. That's what they say he obstructed. So penalties, statutory maximum is 20 years imprisonment. Fine of $250,000 or twice the gross gain or gross loss, whichever is the greatest, and a mandatory special assessment of $100. He's not going to worry about the $100. So there's a bunch of things that he understands about sentencing, that he's giving up his right to vote, possess a firearm, etc., etc., etc. Let's get to the factual basis. There we go. Facts. So now they're going to tell us what the actual facts, and he's agreeing to these, right? He's agreeing that these are true, right? So on November 24th, 2021, defendant, an experienced pilot and skydiver, took off in his Taylorcraft BL-65 airplane, which bore civil registration number nobody cares, from Lompoc City Airport on a solo flight purportedly destined for Mammoth Lakes, California. However, the defendant did not intend to reach that destination. Instead, pursuant to a scheme to gain notoriety and to make money, the defendant planned to eject from his airplane during the flight and to video himself parachuting to the ground and his airplane as it descended and crashed. So, you can't do this. You can't actually just crash planes because you feel like it. Now, apparently the reason why he was doing this, how you might be saying, how are you going to make money destroying an entire airplane? Because an airplane costs a stupid amount of money, right? Well, apparently this airplane was already basically scheduled to be decommissioned. This airplane was past its sell-by date. And the other thing is he had a sponsorship from a wallet company. So a wallet company sponsored this. This airline accident is sponsored by a wallet company. I'm just going to say I'm not, hey guys, why don't I take a lot of sponsorships? Oh, right. So, all right. Prior to taking off, defendant mounted several video cameras on different parts of the airplane and equipped himself with a parachute, video camera, and selfie stick. Now, most pilots don't have a parachute at these small aircraft. That is fairly uncommon. Approximately 35 minutes after taking off, while flying above the Los Padres National Forest near Santa Maria, California, defendant ejected from the airplane and videoed himself as he parachuted to the ground. Using the video camera mounted on the selfie stick and the video cameras mounted on the airplane, defendant was able to record the airplane as it crashed into a dry brush area within Los Padres National Forest. So just thinking that one through, he's crashing this thing into a forest that is a national forest and could have started a fire, right? You could have burned down could have burned down this entire forest. After parachuting to the ground, defendant hiked to the location of the wreck and recovered the data containing the video recording of defendant's flight and the crash of the airplane. So, after you've just had a plane crash, the important thing is to go and hike to the crash to get the video footage and not to go get help, right? Yeah. So to convince you to buy this wallet, I'm going to basically fire an unguided missile at the Earth. Yep. And yeah, that's okay. He had fire extinguishers strapped to himself. Yeah, if you actually if you started a fire there, by the time you got there, there is no fire extinguisher that you could personally have been carrying that would have been sufficient for all of that. So, it's just completely not workable. All right. So, launch of federal investigations. November 26th, the defendant informed the NTSB about the crash of his airplane. On about the same date, they launched an investigation into the crash, and they interviewed him by telephone. The investigator told him that the defendant was responsible for preserving the wreckage and that the NTSB would need to see the wreckage. And this has got to have absolutely terrified this guy, because he knows that he crashed this thing on purpose, right? He knows that he did this intentionally. So he now is like, oh, crap, they're going to discover that one, right? So, all right. Investigator ES emphasized to defendant that the focus was on investigating or identifying the location of the wreckage before he could give defendant further instructions. At the end of that interview, defendant agreed that he would determine the location of the crash and provide it to the investigator. He also agreed to provide all videos of the incident. All right, so they also launched an investigation into the crash. He followed up with defendant and asked defendant by email if defendant knew the longitude and latitude coordinates for the aircraft wreckage. An hour and a half later, defendant responded by email stating that he did not have the coordinates and was still trying to figure out exactly where the wreck was located. Keep in mind, he hiked up to this place. He probably had GPS coordinates at that point, right? Subsequently, on January 3rd, they once again emailed him and asked other things. Has the wreckage been recovered? If so, where is it? And defendant said, I'm not aware of the plane location, which again, not true. Despite his claim that he was not aware of the plane location, he had previously found the wreckage and removed it from the crash site. In early December, he contacted a helicopter company in Paso Robles, California, and asked for help retrieving the airplane. Thereafter, on or about December 10th, they picked up defendant and defendant's friend in a helicopter, and they had driven a pickup truck in that location. They informed him of the location, so obviously he knew it. Their defendant secured the wreckage with straps, and the helicopter subsequently lifted the wreckage, carried it to the Rancho Cisco location, and loaded it into the trailer of defendant's pickup truck. They took it to a hangar, they unloaded it, they cut it up and destroyed the wreckage, and over the course of a few days, deposited the detached parts of the wrecked aircraft into trash receptacles at the airport and elsewhere. So they're cutting this thing up and, hiding it in various places. By the way, guys, if you're thinking hey, do the investigators suspect that I might have done something wrong? This really suggests to them that you did something wrong. Defendant took apart the airplane and deposited its parts into trash receptacles with the intent to impede and obstruct federal authorities, namely the FAA and /or NTSB, from being able to inspect the wreckage as part of their investigation into the November 24th, 2021 crash of defendant's airplane. So defendants plan to make money from posting a video of the November 24th flight. So now here's how he's going to make money. Prior to his flight on November 24th, 2021, defendant has secured a sponsorship from a company that sold various products, including a wallet. Pursuant to that sponsorship deal, defendant would promote the company's wallet in the video to be posted by the defendant on YouTube. Defendant intended to make money by promoting the wallet in the video that would depict, among other things, defendant parachuting from the airplane and the airplane descending and crashing. Consequently, on or about December 23rd, defendant uploaded a video on YouTube that contained a promotion of the wallet and video of, among other things, defendant piloting the airplane, defendant exiting the airplane and parachuting to the ground, and the crash of the airplane. I'm just going to say, guys, as much as I love having big numbers in the chat, I, love getting super chats. I love, getting all of this. Like, I'm not about to go crashing a plane for any of that. Heck, I turned down sponsorships. I just recently, so a company that does investments wanted to sponsor with me, and I was just like, nah. There's a couple of other people who've emailed me for sponsorships. I got to decide whether or not I'm going to do sponsorship stuff. I don't do a lot of them. I've done some sponsorships in the past where I did the Jace case thing, and that was largely because I was kind of curious about it. I did another one. I got to finish the video of it. Where I did I did a review of a flashlight. All I got out of that was the flashlight, so not big money. I've done another one that is a review. I got to get this one finished, but it's a review of a night vision scope. So I'm gonna make that out at some point. And I'm seeing it is an important time. It is. It is this time. So, I mean, I'm not sure about sponsorships. I'm not going to touch anything financial investment, whatever, like that is too spicy for me. But I also don't want to touch any products that I don't want to touch any products that I don't like and that I don't want to use myself. Somebody was saying, was it at least a good flashlight, Runkle? I didn't actually think it was a great. I didn't think it was a great flashlight. I did a review where I said, "Hey," like they basically said, "Will you do a review of this flashlight?" And I did, and I was like, "I don't think this is a great flashlight." So, yeah. I guess the one thing I'm going to hawk in a bit is I will hawk the my hot sauce when it comes out. I'm not going to do Raid Shadow Legends because, quite frankly, I think it's a crap game. So we'll have to see. So, all right, let's keep going here. All right, so he made other false statements to conceal his scheme. He submitted a report where he said that he'd experienced a full loss of power approximately 35 minutes after taking off. And he stated that the airplane engine had quit, and because he could not identify any safe landing options, he parachuted out of the plane. He knowingly made these false statements in order to conceal the fact that he had purposely abandoned his airplane in flight as part of his scheme to create a video to gain notoriety and to make money. And I'm seeing, what is it? Bruce and his son does his vids, which makes them cool. I didn't know his son was involved. That is pretty awesome. And I see, what is it? Time for a reminder. Please like the video. Yes, absolutely. Did I hear back from the Hatchet Sword Company? No. They said that they basically are not doing. They've said that they're basically out of stock for a while, so I don't. Yeah, I'm not. What is it? Raid sucks. Yeah, I'm not doing any. I'm not doing any recommendations for Raid Shadow Legends or anything like that. Just because they're games that I won't, that I'm not inclined to play. So, and if I'm not inclined to play it, I'm not going to recommend it to anybody because why, right? I feel like you guys watch me because I've got some credibility, I hope. And if not, it's real easy to burn that up. So I'd rather not do that. VPN stuff, I get some recommendations for. I get some people asking about VPN stuff. I probably won't do VPNs just because I don't have enough knowledge to actually gauge that. And this is a good aspect here. I quit watching EDB on live. I pay for YouTube Premium, so I won't have commercials. I watch on replay, so I can fast forward through ads. Yep, absolutely. What is it? If you won't do raid ads like everyone else on the internet, maybe hawk ball shaving machines like everyone else on the internet. The only reason I've contemplated that one is just because sometimes it would be funny. So I wouldn't cover that one on anything else, but just like when I did the video talking about the silver balls, that might be a fun time to be like, and let me go into, but I mean, I'm just going to tell you, I'm not going to test this machine to, for any of that. So, yeah. So you can't make a living on YouTube ads without a giant audience. That's why people do in-video sponsorships. Yeah, it's tough. I got to make a call. So we'll just have to see. All right. So let's have a look. And the problem is that the products I like typically don't need some YouTuber to do ads for them. So that's kind of the wrinkle on that. All right. But I'm at this point I'm a long way away from my sort of goal of pro bono law. Long way away. Sentencing factors. Defendant understands that in determining this, the court is required to calculate the applicable range. Guidelines are advisory only. And so they agree to the appropriate ones. Does it actually give us a calculation? The U.S. has weird calculations. They reserve the right to argue that a 2-level upward adjustment is appropriate. And they're asking if any probation or supervised release that he be prohibited from applying for any type of pilot's license. I would think that they would not give him any kind of pilot's license in any event. All right. Yeah, the GWAX, that would go well for the GWAX, I gotta say. So there is some overlap there. That's the thing, is it would be appropriate on situations where it's funny, and that's about it. And I see Hedgehog in Space saying, pick one Canadian law to switch with one U.S. law. I mean, it would have to be something firearm related. So I guess the ban list. Bo Johan, consistently confused, moving to Runkleton for Runkletarianism. Welcome aboard. Midnight Drury, thank you for the gifted membership. Somebody else is saying that I need to check. Somebody is saying that I need to check for a Twitter message, but it's too. I get too many Twitter messages. It's hard to find them. All right. Let's keep going here. All right. Do they say that they want for what the actual sentence he wants is? So they're asking for at least 18 months. So they want some jail. And quite frankly, I think some jail is appropriate. Now, I mean, I saw a lot of people online talking about like, hey, this guy's going to get 20 years. And I'm sitting there going, God, I hope not. I mean, I think that this is a bad thing that he's done, right? This is a bad thing. But at the end of the day, I don't think 20 years is appropriate. The 18 months that they're asking for seems suitable. So that seems suitable to me. All right. So I see somebody saying do racket style ads, just throw jokes in it left and right. Maybe. I got to decide on that. Runkle, avez-vous déjà essayé le parachutisme? So in English, that is, have you tried parachuting? I have not. And I got to say, I am a little afraid of heights. I do not like heights. Now, I've actually contemplated going skydiving because I think that I think it might be a way to get over the fear of heights, is to go skydiving. But skydiving is A, expensive. B, I will tell you, it'll be one of those things where it's like, I'm going to be freaking terrified. I will be freaking terrified if I do it. But that isn't necessarily a good reason to do it in the first place. I don't know. Chat, what do you think? Should I try going skydiving sometime? Is that something I should do? I don't know. Especially because my life insurance probably doesn't pay out if I die skydiving. So I'd probably have to buy a second policy for skydiving. So and I see people saying only if I post the video. If I go to skydiving, I will tell you that I will absolutely strap a GoPro on myself and I will film it. I'll probably film it and post it without audio because the audio will probably be, and we're past 2 hours. The audio will probably be shit, damn, why'd I do this the whole time? What would your wife say? She would probably want to go with me if I went. So I think that her opinion would be, let's do it. Bring your Ridge wallet if you go skydiving. Now I make my own wallets. So people are saying do it indoor. I don't know. The indoor one doesn't seem like it's I don't know if the indoor one makes makes sense. Bluebell is, I'm a paratrooper, and I'd say I wouldn't recommend it if you're scared of heights. It's awesome, but not something to try if you're that scared of heights. I feel like sometimes the thing to do is to jump in at the thing that terrifies you. So I don't know. I haven't decided on this one. It's really tempted. If I had a bunch of money, I would try to get into what I'd love to try to get into is getting a pilot's license. But the pilot's license thing is just stupid expensive. So like to get all of the air time on that, to rent a plane, all of that stuff. I'd love to get the license to fly like a small ultralight and so forth. So I would love to try. I'd love to try flying sometime and being able to do an actual flight there. So we'll have to see. All right, let's do a swoop here. And I've got some super chats to cover here. Trufflehound, I view politics like an ibis, Australian bird. There's a left wing and a right wing. Both wings are attached to the same bin chicken. Nice. Rhineman YYC, his parachute was a sport rig, not an emergency parachute. Pilots flying skydiving loads often wear emergency chutes. Good to know. That probably also got people going, that seems suspicious. That seems sus. Time, your commercials would probably have to be having Runkleisms and be worth watching. I'd hope they'd be funny. Is Runkle fluent in French? Not fluent, I guess. Je peux parler français, mais pas tellement bien. J'ai besoin une deux semaines. Uh, yeah, it takes me a couple of weeks before I can get my brain into French mode. And then once I get into French mode, then I can speak fairly comfortably. So, when my wife and I went to Paris, we went to Paris on a vacation, and I like the first day or two, I was useless. Like I'm trying to speak French to people, and it's like, je mo pas. Like I was just struggling. Um, and then once my brain gets into it, I get back into sort of thinking in French and being able to function in French. And I was actually having trouble with. I'd be talking to my wife, and she'd say, "Hey, what's what do you want to do today?" And I'd respond in French, and she'd be like, I still don't speak French, right? I'd be like, sorry, in English, here's what it is. And I mean, I was good enough in French that I could go into like a Paris coffee shop or whatever and order something in French, and they wouldn't they'd speak to me back in French instead of in English. So my wife and I went to this one little restaurant, and I had steak tartare, and I forget what she had. I remember the steak tartare because they tried to argue me out of it. But like I ordered in French, and she ordered in English, and the guy wasn't like stopping me to be like, let me speak English to you instead, even though he spoke great English. So I take that as a pretty good sign. Graceful Answers Ministry, I heard that you think in that language. Is that right? If I've been speaking French for a bit, like, in a situation where it's all French around me, then my brain will switch over and I can start thinking in French again. Right now, I speak too much English, and so my brain is locked into English mode. So I think in English, and what is it? Basically, that's just how it is. Now, the reason why I can speak French is that I went to a French immersion school. So from about age 3, I was going to school en français. And so my French grammar is not terrible. It's not awful. So I'm just, it's difficult there. Do I dream in English or French? If I'm in France, like when I've been in France, I start dreaming in French. But mostly I dream in pictures and video and stuff happening. My dreams don't tend to have a whole lot of language. Apple Silver Runkle, apportez-moi votre sauce la plus piquante. I'm not sure when the sauces will be done. I suspect that there's going to be a run on the sauces because there's 150 bottles, which is going to be split, I think, between the hot and the less hot. So we're going to see some challenge on that. And somebody was asking a question that I wanted to answer here. Where'd it go? If you ever want to represent the Tabernacle First Nation, you pretty much have to speak fluent French. Folks, if you're not sort of a French speaker, the Tabernacle First Nation is not a real First Nation, because Tabernacle is French swearing. French swearing is basically all blasphemous, basically. So it's all like references to religious things, tabernacle, tabernacle, it's all of this is that. Are your early memories in English or French? My earliest memory doesn't really have anybody talking in it. So, yeah. All right, let's, so we covered that one. I went skydiving with my grandmother for her 91st birthday. If we can do it, so can you. P.S. They don't let you bring your own GoPro. They sell video. I will insist that I bring my own GoPro because if I can't bring my GoPro, then they can go hang. So I'll bring my GoPro. All right. And what's the story behind your Twitter profile picture was a fun question. So if you guys don't know, my Twitter profile picture is basically rod stock. So it's like a bunch of metal bars. And the reason why it's metal bars is that I just gotten started on Twitter. And I didn't realize that people on Twitter kind of judge you if you've got the starter profile picture, and I had no reason to change it. But I was posting something, and somebody was like, "Oh, look, um, it's the egg poster or whatever," and I was like, "Oh, is that really something people judge you on?" So I was like, "All right, fine, I'll put up a profile picture." And I was in Home Depot at the time, so I literally just leaned over, like looked around, went, what's visually interesting at the Home Depot, when it was this rod stock, took a picture of that, and then put it up as my profile picture and was like, hey, now I've got a profile picture. And I've never changed it. I've never changed it at all. Melanie Palais, your French is quite excellent. Thank you. I only think I'm okay. One of these days, I would love to get better at it to the point where I could do it in court. Safety hazard, helmet mounted GoPro is a potential line snag. I think I'd try to go for like chest mount would be the way to do it. So have I ever been gopher shooting? I have not. I would. I just need to find a farmer who wants me to do so. So we will we'll have to try that sometime. But all right. Let's now we are past the 2-hour mark, so let's look at what cases we've still got to cover here, because there's a whole bunch of them here that we got to cover. All right. Let's let's, I guess, do the Giuliani one now. There's another one that I want to cover as well. So, and Dusty's saying we shoot them every week. That would be awesome. So give me a shout. Ian, you should try D&D in French. That one would be hard because I don't know the names of any of the monsters. So that one I don't know. So what's this? Here for years. Has Ian been flying solo for the whole broadcast? Yes. People are busy today. Rob is making an urn, which is important. And generally just people are busy on Monday evening. It's not the greatest night for that. So if somebody wants to come on, I'll bring them on. But for right now, yeah. Good Guy Biker, I can't answer this question on a stream. We'll have to talk. So shoot me an email there. Steve Earle, come to Cold Lake. I'll take you. I've got friends up in Cold Lake, so I'll have to do that at some point. All right. Jonathan is saying, I love eating groundhog. I've never actually heard of anybody else eating groundhog, so that is interesting. Worst game show ever time. I don't actually have I don't have one for today. And yes, this is important. Sorry I couldn't make it tonight. I'm working on an urn that needs to be ready to fly to Honduras by Thursday at 5 a.m. Stressed lol. Yeah, I can absolutely see that. Prototopics Campfire Kingdom is coming out soon. Ooh, I got a thing for that. I got to do some leather work for that. This I'm going to make out of leather. So I'm going to put this on a panel for the DM screen that I'm working on for Prototopics. And we have Trials of the Century Wednesday. Yes, Rob, make sure you're ready. So, all right, let's bring up this one. Now, I'm just going to give some cautions here, folks. Allegations on this one are unpleasant. Some of the allegations are spicy. Some of the allegations are just gross. So we're going to go through them and we're going to sort of see what we can do on all of this. But yes, and this is, do you do leathercraft? I do. I do lots of leather work. So, oh, and I got a swoop. Thank you for the reminder, chat. All right. So this is Noel Dunphy and Rudolph Giuliani and a bunch of Giuliani's companies, as well as John and / or Jane Doe's 1 through 10. All right. So, this is who they're suing. So she alleges the following causes of action. Breach of contract, non-payment of wages, unjust enrichment, promissory estoppel, negligent infliction of emotional distress, intentional infliction of emotional distress, sexual harassment, quid pro quo sexual harassment, retaliatory dismissal, legal malpractice, tortious interference, and defamation. So, quid pro quo sexual harassment basically means if you do X, I will do Y. And / or if you don't do X, then I will do Y, right? Where there's some sort of, trade on that. Catherine Fraser, is Trials of the Century going to be on both channels? I think it's going to be alternating again. And I think this one is going to be on Rob's channel, I think, to start. But we'll figure that out. Trials of the Century won't be members only. So it's going to be open to everybody. So all of that, you don't have to pay any money for that because I know cash is tight. I know that a lot of people are short on money. It's a tough time. So we want to make sure that that's open to everybody. And I see somebody saying homemade wallet's very nice. I'll show my wallet. It's not the greatest. This is a wallet I made for myself. It's not the greatest. I used the wrong kind of leather, but I got to make some other ones. Will I be doing more on the C21 updates? I will, not so much in this video. I'm going to be doing video on. I'm going to be doing videos on those, on some of the issues on that. So that will be something we do. Runkle, explain promissory estoppel. It's been a while since law school. So promissory estoppel is basically when you make certain promises, you might be barred from certain lawsuits or certain claims. So that's kind of the, they're going to explain the specifics here, but it gets complicated. What leather did I use? I used a pull-up leather, and the pull-up leather is was not the right thing. Dusty says Dancho is a rock star for gun owners. I'm pissed off at Dancho, and I'll tell you why when I cover it. Dancho screwed us, and she doesn't even. I don't think she even knows it, but she screwed us, and unfortunate. There it is. All right. Plaintiff began her employment with defendants in January 2019, having been retained for business development work and other work. Plaintiff was professionally qualified for the work offered with a degree from Columbia University and 17 years of business experience, mainly in business development, marketing, and communications. I'm just tagging that. Plaintiff's Ivy League education, work experience, and large network of potential clients for Giuliani made this salary Giuliani promised reasonably believable and justified according to the marketability of her skill sets and the value to defendants' lucrative business operations. The salary was comparable to that of Maria Ryan, who was paid approximately $1 million per year. In 2018, Maria, due to holding a consuming full-time job out of state and running her family household out of state, would work in person for Giuliani. I have never made $1 million in a year. I will probably never make $1 million in a year. In fact, if I'm on track to make $1 million, I'll probably end up not doing so. It's just, I'd probably hire people if I was making $1 million a year. So I don't I don't see that as something that's going to happen, but I got a little bit of envy. You know, some nights I'll do a video or do something and make like $8. So, yeah, it's just, I'm never going to make $1 million. So at all material or times material to the cause of action alleged herein, defendant reported directly to Giuliani, who exercised full supervisory control over plaintiff's work for Giuliani in his personal capacity as well as professional capacity as a managing member. So basically, he was in charge. I say, believe in your hot sauce, Runkle. I don't think my hot sauce is going to take off, and make me a millionaire, but maybe I'm wrong. I just don't know that there's that much money in the hot sauce business, but maybe I'm wrong. All right. Defendants routinely expense plaintiff's activities via the official corporate credit card. Plaintiff did on occasion incur employment-related expenses on her personal cards, which remain unreimbursed to this day, despite the promises of defendants to cover such expenditures. I'm going to say, of all the claims in this one, I'm not that upset about that one. I don't imagine that that's enough for, for the 1 million aspect. All right. From the beginning of plaintiff's employment in 2019, defendants under Giuliani's leadership maintained a toxic and sexually hostile work environment pervaded by disparaging and discriminatory comments directed against women, minorities, and those suspected of disloyalty on a thin to non-existent evidentiary basis. Despite attempting to cultivate a public image of himself as America's mayor, Giuliani frequently made racist, bigoted, anti-Semitic, anti-LGBT, and misogynistic remarks, often during confused and hostile alcohol-laced tirades, further reinforcing the toxicity of the workplace operating under his direction, adding to the chronic and pervasive violations of applicable New York State and New York City laws prohibiting discrimination in the workplace. Now, this is one of those things that we're going to have to see, because she says that she's got some evidence of all of this. And, what is it? We're going to have to see what that evidence is, because some of these allegations are shocking, to say the least. During this time, publicly documented abuse of alcohol worsened, fueled in part by his caustic and expensive public divorce, mounting political controversies, legal entanglements, and public humiliation before, during, and after the 2020 presidential election, and violent January 6th attack on the United States Capitol. On every day of the week, Giuliani would begin drinking shortly after awakening and would continue consuming alcohol persistently and in excess, affecting his behavior as her boss and lawyer. Now, guys, I'm just going to say, I like a drink, right? I like a drink now and then. You'll note that this is the first alcoholic beverage, and I'm going to finish this one in now. Finished. So, and I'm going to start another one. But I don't start drinking when I wake up. And I'm certainly not going to start, and I'm not going to continue. I don't do the drinks for super chats thing, even though it's quite lucrative from what I've seen, because you're here hopefully for legal commentary, right? So I don't think I can do that if I'm smashed. But oh, hey, a burr from the evil plant that is outside. I'm just gonna carefully chuck that into the trash. And I think that my second drink will be here we go. A Caesar. All right. So, but if you're ever sort of in a place where you find yourself waking up and you need a drink or three in order to start the day, then maybe look into it. maybe look into whether or not your life is where you want it to be, because that is not a great place to be existing. It's and I've seen so many people destroy their lives on that sort of thing. Addiction is one of the leading causes of lawyers getting disbarred. So if that's you, get help. But the other flip side of this is, if that is you, if you are doing all these sorts of, it doesn't necessarily forgive or excuse your actions. So you still got to be a decent person, even if you're dealing with an addiction. All right. Despite plaintiff's objections and perseverance, maintained in earnest hopes of improvements within defendant's workplace environment, as well as the hope that steadily increasing sums of deferred compensation would be paid, egregious and unlawful conduct by defendants persisted through 2021, when plaintiff was illegally discharged by defendants. So she says that she was fired and improper. Eric, congratulations on 4 years sober. I hope that I'm not sort of triggering anything when I have a sip on stream, but congratulations. That's an excellent thing to be doing there. All right. Yeah, and I see Rudy was fantastic in the 1980s and 1990s, cleaned up my city. Shame on him. Sometimes people change or weren't the people you thought they were. At the beginning of plaintiff's employment, Giuliani was embroiled in acrimonious, high-profile divorce proceedings in which he and his then-wife litigated the division of tens of millions of dollars in marital assets. At the time, he also served as the personal attorney to the President of the United States, frequently attracting political controversy, intense media coverage, and public scrutiny of his every action. Now, this is the kind of thing that would put a toll on anybody. Like when you're wondering when people change or how people change, divorce actually causes a lot of issues, right? There are a lot of people who've come out of a divorce not being really the same. Does your hot sauce have vinegar? I'm going to have to pull up the ingredients on it. I don't think it's a vinegar base. Give me a second. I believe, because the actual, making it was, yeah, it was sort of so let me just pull that up. I'm just pulling up the ingredient list, and hopefully that's not sharing to stream. Good. All right, let me just pull this up. I've got the ingredients. Where is the ingredients? There we go. It doesn't look like vinegar, so these should be just a sauce base. So yeah, these I'm hoping. I've made, so this, the hot sauce I'm making, I've got a bottle of sauce in the fridge. It's really good. I really like it. And that's the one that I'm trying to get remade for this. So if I'm hoping that this sauce will be basically the same stuff that I've made, that's in my fridge. And if so, then I will be really, really proud to share it with you guys. I will be happy to be able to say this is the stuff I made, and that this is the sauce, because that I think will be fantastic. If not, then we'll see. I'm hoping it's going to be really good. All right. So at plaintiff's insistence, plaintiff was required, as a condition of employment, to consent to receiving deferred compensation and be an off-the-books secret employee. No male employees were subject to this arrangement, establishing a strong presumption that Giuliani's workplace conduct was disparate and discriminatory based on the account of sex. Now, I'm just going to say, folks, if you're working for a place and they start saying, hey, you know what, we can't pay you on time, we'll have to pay you next month, and we'll have to pay you later, and so forth. That's a real strong sign that things are getting pretty terrible. So, yeah. Although the deferred compensation agreement was far from ideal, plaintiff reasonably believed that Giuliani's present and future earning potential was sufficient to cover the amounts promised, and was forced by binary choice to accept and detrimentally rely upon the offered terms, expecting that transitory financial issues would ultimately be resolved. Red freaking flag, as people are saying. And yeah, anyone wanting you to be a secret employee is a red flag. Yep. That's a sign the company's going under. Yep. My mom tells me a story that she was working at this place, and they said, hey, we can't pay you this month. We're going to pay you next month. And my mom immediately started farming her resume out because she knew that the company was going under. And they were like, hey, we're asking for everyone to defer payments another time. And she was like, no, pay me now. And they're like, well, all the team players are doing it. She's like, pay me now. Also, here's my 2 weeks notice. So she took her money and she left. And she got a good job before everyone else was sending out their resumes. So she said it was a good move. All right. During plaintiff's employment with defendants, Giuliani sexually harassed plaintiff and demanded sexual favors as part of a pattern of quid pro quo sexual harassment. By 2021, Giuliani's desire had shifted on and off to another employee, resulting in his impermissible and retaliatory discharge of plaintiff from his employ, not on the basis of any legitimate reason, and without issuing compensation for work already done. Basically, the allegation here is that he got interested in, a different, the younger model or whatever, and booted her out the door. And she didn't receive any back pay or severance, she says, nor any reimbursement for employment expenses incurred on personal credit cards, despite his promises, leaving defendants unjustly enriched following their willful and illegal discharge of plaintiff, in part on the account of sex and in breach of contract to pay wages duly earned, despite Giuliani's clear and ambiguous promises to pay duly earned compensation on which plaintiff relied, leaving plaintiff injured upon non-payment. Let's talk a little bit about unjust enrichment. So unjust enrichment basically means that through no proper means, somebody else was benefited at your expense. And so what that means in this case, so sometimes you'll argue unjust enrichment as like an alternative to other to other things. So, for example, let's say I agree. Let's say I am going to, let's say I'm going to buy a car from, or hell, something I just did. My friend who's my sword guy, I've just sent him money to say, please make a kukri, because I am going to make a sheath for that kukri, and I am going to. That's going to be one of the things that we auction during the fundraising streams, right? So when we're trying to fundraise for the Children's Hospital, I'm going to be putting that kukri up as one of the items that is available for for people to bid on. Now, I've sent him money to start work on that. Let's say he doesn't start work on it and instead just keeps my money. And, that would be something that makes me upset. Now, I think we actually have a, that I've got a valid contract there to get this. But let's say the court says that there is no valid contract. That the court says, you know what, you never actually had a contract. I could still sue him on the basis of unjust enrichment, on the basis that he's got my money. And even if we didn't have a valid contract, there's no basis for him having my money. So that would be sort of the argument there. That would be sort of the argument there. Did he agree to make the knife, or did you just send him the money? He agreed to make the knife. So, yeah. For realsies, I need a sheath for my kukri. I'm going to get this kukri, and I'm going to, I'm going to properly, what do you call it? I'll make the sheath for that one. All right. So I'd like to get a falcata myself. He can make you one of those too. My sword guy does all sorts of things. We got some questions about that. Special KL was saying it's a clown. Why would you be in fear of your life with a foam weapon? These are typically very realistic foam weapons that they were carrying. I can tell you that in the dark, you would probably not be able to tell the difference necessarily. I'm pretty sure he has both a sword guy and a knife guy. This is actually accurate. So, yeah. I can get my kukri in a second. Hey, whatever happened with the 4-H goat? That's going to be in a long, there's going to be a long legal battle. It's going to take a while. Civil cases move slowly. Dayslav Act Man Carry. I can't stay, but keep fighting. Thank you very much. Thank you for the $5 super chat there. Time, thank you for the $10 super chat. He was married to his second cousin. Yeah, that's a thing. Whoops. And Time is saying you have a sword guy. I do. My sword guy is online at SGT Blades, SGT Blades.com. And what is it? He does great work. Give me 1 second. I'm going to be right back. I'm going to bring the kukri. So I'll just be right back. We're just going to do that. All right, let's make that image go away there. All right. So people were wondering what a kukri looks like. So this is the sheath. I didn't make this sheath. SGD Blades made this sheath. I will, it's SGT. Somebody was saying that they thought it was STG. It's SGT. And, oh, I got to embiggen. So somebody's saying, is that the Gurkha blade? Yep. Am I okay to show this on live? Yes, it's not a firearm. And you can see, let me just rotate. There you go. SGT. So I use this a lot, believe it or not. I did yard work with this. I've taken this camping. I've prepared meals with this. I've cut down trees with this. I've chopped up firewood with this. All sorts of things. This is a great, useful knife. Somebody's saying, do I shave with it? No, I don't think I've kept this one sharp enough. I got to actually run this through the sharpener. But yeah, it's a good knife. So I'm getting another one made, and I'll make the sheath for it myself, and then yeah, you guys can bid on it, and it'll be I think it'll be a pretty awesome pretty awesome thing. Do I know what alloy it is? I don't offhand. We use that for coconuts. It would do a great job on that one. So, yeah. I still think there's a certain VA-based lawyer who will do his best to win that. I mean, he's more than welcome. So, yeah. All right, let's bring this back up. All right. So at one point, plaintiff attempted to find some value in an otherwise difficult situation by requesting Juliana's assistance in finding gainful employment with other organizations. with which defendants maintained ongoing relationships. Despite plaintiff's qualifications and satisfactory work, Giuliani refused. In his refusal, Giuliani became spiteful and hostile towards the thought of plaintiff's income continuity, demanding that plaintiff remain silent about all associations with defendants. Also not a good sign. What is it? Watch Forged in Fire. They make knives and swords live in competition. Absolutely. So I would love to check that out. Yeah, people are asking, like, what is this knife for? It is... this is a general purpose. Like, you can do all sorts of things with this. I find them so tremendously useful that if I didn't think I would get in trouble for them, I would probably just try to carry one of these and walk down the street, but not so much. Does he do battle axes? He does. I want to have 2 battle axes under my family clan crest. Look him up. He does indeed do battle axes. So, yeah. All right. At these times, Giuliani threatened plaintiff with further retaliation if she did not stay silent, stating that his private investigators and political connections to President Trump enabled him to retaliate in other ways, express and implied. Plaintiff reasonably believed Giuliani's threats of retaliation, especially owing to the extreme power imbalance and plaintiff's lived trauma as a survivor of domestic abuse, a fact well known to Giuliani. Oh, that's difficult. All right. In January 2019, plaintiff offered to represent plaintiff pro bono in legal actions surrounding assault and abuse that she suffered as a victim of domestic violence, who was attempting to heal. He freely offered his legal counsel and expertise, explaining that he wished to help plaintiff achieve justice, receive compensation for physical injuries, and access other remedies available to survivors of violence. Within the context of an attorney-client relationship, plaintiff diverged details covering the most traumatic and painful experiences of her life, reasonably believing that the former United States Attorney for the Southern District of New York was knowledgeable about matters of law, trustworthy, motivated to assist a crime victim in securing justice and closure, and capable of providing effective counsel. I'm just going to say that at this point, all of this opens up, this opens up the potential that they're going to have to invade their entire attorney-client relationship, right? That is going to be a big, a big thing there. So we'll have to see what happens. And some people have asked for the link. I've just dropped the link to SGD Blades. So, and somebody's saying, how about a Discord page for posting pictures of pokey cutty things? Maybe I'll have to add that to the Discord. I don't know if you guys have my Discord link. I will pull that up here. Yeah. So there's a link to the Role of Law Discord. So there you go. This is a civil suit. So, yeah. All right. I don't know if you ever saw the series Big Giant Swords, but that guy is still doing them and posting videos on YouTube. That is awesome. This is the kind of ad I should do. The kind where I get no money for it. I just am sharing products that I like. Yeah. I know the guy behind this company. He's a good guy. It's awesome. All right. The quality and effectiveness of Giuliani's counsel proved to be the exact opposite of what plaintiff expected from the former federal prosecutor. Giuliani was frequently intoxicated while discussing matters of law, and he leveraged his counsel to pressure her for sexual quid pro quos during lawyer-client consultations. At times, he seemed unable to remember key facts or to follow the basic details of fact patterns relevant to the case. Plaintiff would frequently need to remind Giuliani of said details. Ultimately, the statute of limitations expired, leaving plaintiff without redress and without knowledge of her loss of redress until it was too late. This is a situation where she could sue the guy, right? This is something to sue him over, and she is. So, yeah. Get sponsored by these guys. I don't think SGD Blades makes enough to sort of throw a sponsorship my way. I pay full price, or I might get a friends and family discount. I don't know, but I pay for the stuff I get from it. So, yeah. All right. Guys, the thing about limitation periods are not like being late for an assignment in school, because typically when you're late for an assignment in school, the teacher might give you an extension or you're losing marks on it and so forth. Whereas if you miss a limitation period, it can be that you have a tremendously good claim, like a claim that is absolutely going to bring you in money, right up until the day after the limitation period, at which point your claim is complete garbage. You can't bring it. So, yeah. Is sergeant short for, or SGT short for sergeant? It's not. It's actually the guy's initials. So, yeah. All right. As a result of Giuliani's legal malpractice, plaintiff was re-victimized, re-traumatized, left without legal redress, and substantially worse off than before Giuliani agreed to represent her in hopes of securing justice against an abuser. Instead, Giuliani leveraged the traumatic details of plaintiff's prior victimization to fulfill his morally bankrupt sexual compulsions and fetishes. That's a hell of an allegation, and we'll have to see if she's got evidence, because if she's got evidence, Giuliani could be having a real rough time. Rudy Giuliani, the former U.S. attorney, once hailed as America's mayor, and this is her claims, I'm just noting that, I'm just quoting here, is a sexist sexual predator and abuser. Plaintiff did not immediately bring this action owing to reasonable fears of retaliation, re-aggravation of prior trauma, and threats. Plaintiff refuses to be coerced into silence any longer. As both plaintiff's employer and attorney, Giuliani's willful, wanton, and wrongful conduct occurred with extreme malice and conscious disregard for the law, for his obligations as a lawyer and boss, and basic standards of ethics and decency. Whew. Consequently, plaintiff petitions this court for punitive damages on all causes of action alleged herein. Furthermore, plaintiff alleges that each and every cause of action alleged above contributed to a pattern of intentional and negligent inflictions of emotional distress. And I see, people are noting she has tapes, and I want to hear the tapes. Like, I want to see that, because ultimately, tapes can show different things. But, I deal with criminal law where sometimes people are like, I've got a tape that shows that I didn't do it. And they're not always the greatest. But if she's got tapes that back all this up, he's in some real trouble on this. The other thing that is dangerous, that is as a lawyer representing your employees, because you have an obligation to clients that is a fiduciary obligation. It's a higher level of obligation. You don't want to mix that obligation with your obligations to your employees, which are much lower than fiduciary. So E. Ness is asking, how old are these allegations? When did this happen? It looks like 2019. So they are a little old. All right. At all times material to the cause of action alleged herein, Giuliani was a resident of New York, in the county of New York, in the state of New York. Additionally, the Giuliani entities were also in New York. Furthermore, much of the actionable conduct alleged herein occurred while they were in New York, despite periodic employment-related travel to other jurisdictions. So that's just basically saying this is why this should be heard in New York. Wherefore, plaintiff demands compensatory monetary relief for breach of contract, unpaid wages, and legal malpractice in the sum of $3,100,000 plus interest, or in such sum as the jury may decide, along with punitive damages in an amount to be determined by a jury, prejudgment interest, costs, and disbursements of this action, as well as anything else the court will give us. You always ask for anything else the court will give you, because, furthermore, they want punitive damages on each and every action listed, and they want attorney's fees. Now, I note the if plaintiff should retain counsel at any point during this proceeding. She filed this pro se, which is nuts. absolutely nuts to file this pro se. If she should retain counsel, retain counsel. Absolutely, you want a lawyer on this one. So, I mean, maybe she's got some legal training because this was well drafted overall. But get a lawyer for freak's sakes. Now, I don't know if there's a limitations period issue on this one. We'll have to see. But she's made all sorts of allegations, and this is going to be, exceptional. One of the allegations that's been made is, that she says that Giuliani was selling pardons. That's a problem because pardons should not be for sale. That should not be purchased. So I don't know, but this is good work. I didn't realize it was pro se until I got to the bottom of it. That's surprising. So get a lawyer. I'm going to try to follow this one as best I can, I guess, although I kind of want to avoid. I don't usually cover the political cases, but a lot of people asked me about this one, so I thought, yeah, let's have a look. All right, I'm just what is it? Looking over here, just let's bring up. I guess got one last case. Well, it's actually a pair of cases, but one last pair of cases that I would like to cover. All right, and this is Torres and Botanic Tonics LLC, as well as 7-Eleven Incorporated and Doe's 1 to 10. And I see somebody saying it's not really politics. Whenever there's a politician involved, it gets political. There's going to be allegations that she's doing it for political purposes. There's going to be all sorts of things. I got to decide if I want to wade into this one because it'll be messy. All right. Swooped. All right. We got a couple of super chats here we should cover. Kristen M96. Wonder if you will say he gave her employment to cover his legal advice representation. Maybe. We'll have to see what agreements they've got and what all is there. Here for years, because the puppers need treats, I will make sure the puppers get their treats. The puppers do need treats, and they're good puppers. Although Zora was an absolute little crap. Let me tell you the story about how Zora was being a crap. First, I'll note Chris Mullen, thank you for 5 gifted memberships, and Midnight Drury, thank you for another gifted membership. Much appreciated. And just as a reminder, if you're here and you're enjoying this, please like the stream. But so here's how Zora was being a crap. So Zora last night, Zora loves, oh yes, I also got to cover this one. Thank you for the reminder. I was going to forget. Zora has been really enjoying eating the cable I've been trying to run out to the garage so that I could do garage streams. She's been just devouring those things, and she went through like 3 or 4 of them. So I ran them out. I ran one along the ground and I covered it with boards. She tried to dig under it. She wasn't successful, but she came real close. So I was like, you know what? Before I get this, at some point, I got to run a proper cable through a pipe. But so instead, what I did is I'm running it through the air. I put some aircraft cable between my house and my garage, and this Ethernet cable goes out that window and then runs along this, it's sort of strapped to this overhead aircraft cable, and then it goes into my garage. So Zora went outside, and it's too tall for her to jump, I think. It's like 7 feet up. But she sat there and she looked at it. And she looked at it. And I think that little crap was sitting there going, I want that cable. and I can't get that cable. How do I get that cable? So she was annoyed. So last night, I go to bed, and Zora is normally sleeping where I sleep on the bed, right? She's normally I climb into bed. She's sort of warmed things up. Nope, she's sleeping on the floor. She's on the floor. She's like, nope. But then when I go downstairs, um, she jumps up on the bed and she spreads herself across it. And she's like, nope, I've covered the whole bed, like my whole side of the bed. So I'm like, okay, Zora, move. So I go and like push my way in. And then Zora goes and is like, well, screw you then. Because normally Zora moves out of the way. And then once I get into the bed, she'll go and she'll put her head on my legs. Instead, she's like, no, I'm not moving. I'm not moving. I'm not moving. And then finally, once I'm like, I'm getting into the bed, she goes and she steps over Mrs. Runkle and sleeps on the other side of Mrs. Runkle. Just like, screw you, buddy. Just like an absolute screw you, buddy. How dare you keep me from my cords? So I was just like, wow, I'm on Zora's shit list today. I think she kind of forgave me a little bit because earlier today I went to have a nap at lunch, and she came down and she was like, "Oh, I'm gonna, snuggle up again." So I think she might have forgiven me now, but she was pissed. I think she was unhappy. So yeah. All right, back to back to this. So why is 7-Eleven and Botanic Tonics being sued? Well, this one is kind of funky, I think. So they are suing because Botanic Tonics was the maker of a character called Feel Free Wellness Tonic, which the plaintiff says was falsely advertised and misrepresented. Botanic Tonics advertised its Feel Free Wellness Tonic as a safe, sober, and healthy alternative to alcohol. Botanic Tonics utilized targeted advertising on social media to reach its desired customer base, which included individuals like plaintiff who had battled with addiction in the past. Now, guys, I looked up some of the ads, and I'm not going to show them here just because it might give Botanic Tonic an argument to try to, issue a takedown or something like that. But they say things like, when everyone around you is drinking, you can feel free, and that kind of thing. These things were actively, they appear to me, looking at these ads, like my read on them is them basically saying that they are an alternative to alcohol, because a lot of people who are sober, they go to parties, they want to, have something to drink that is not alcohol. And so this is kind of that market that they were allowing for. So they also advertised it with the hashtag alcohol alternative. That seems pretty, pretty specific, right? So in advertisements and informational materials, Botanic Tonics characterized Feel Free as a kava drink. Kava being relatively harmless from the South Pacific that acts as a moderate depressant, inducing a sense of calm or relaxation. Botanic Tonics stated that Feel Free was safe, healthy, and not addicting, stating that it was no more habit-forming than sugar or caffeine, and that it had no side effects. Despite these misleading market statements, Feel Free has the potential to be highly addictive. Contrary to the marketing, Feel Free's primary ingredient is not kava, but kratom. Kratom is an opioid that carries similar risks of addiction as controlled narcotics. The FDA and DEA have warned that kratom can lead to addiction with significant detrimental side effects, and the DEA has characterized it as a drug and chemical of concern. Accordingly, addiction rehabilitation centers in California include kratom as one of the harmful substances for which they treat patients, and they do so using similar methods as those used to treat opioid addiction. Yeah. Um, I'm just going to mention as well that in Canada, I don't think this product would have been on the shelves in Canada. I haven't been able to find any evidence one way or the other, but I'm pretty sure that it hasn't been on the shelves in Canada because Canada actually does have some restrictions on kratom. It's legal to buy, and it's legal to to possess, but you can't sell it or distribute it in any fashion that suggests. And I see that I'm getting the pronunciation of kava wrong, but you can't buy or sell it in any fashion that suggests that you are going to be using it as an ingredient in food for humans or pets. So kratom beverages would be right out in Canada. So kratom, especially at the concentrations used in Feel Free, is also responsible for a variety of side effects in users that range from the moderate to severe, which include nausea, sweating, itching, dry mouth, constipation, increased urination, agitation, and trouble sleeping. Respiratory depression, seizure, tachycardia, high blood pressure, vomiting, liver failure, addiction, withdrawal, hallucinations, psychosis, cardiac or respiratory arrest, and coma. And I see people saying kratom. Okay. So this sounds like a late night medication ad in the States. Caution, this product may be associated with everything from death to, so yeah. So unbeknownst to customers, they not only added kratom in large amounts, but also manipulated the formula to magnify the effects of kratom and induce a quicker, longer lasting, and greater high, which sounds like they're trying to deal drugs, right? And this particular plaintiff suffered from alcoholism. So he's a guy who's got some addiction issues. He entered a rehabilitation facility in 2014, achieved sobriety, and was thinking, hey, this would be a great alternative. And within 3 months, he had developed a strong addiction to the product. He was drinking 10 per day and spending $3,000 per month on the product. Whoops. He could no longer function without it, developed severe withdrawal symptoms when he attempted to stop using it, relapsed and began drinking alcohol because, that often happens. He was admitted to the emergency room with symptoms associated with severe opioid use, including vomiting, lapses in consciousness, delirium, and psychosis. And then he went to medical detox and got a rehabilitation facility. Caused him to lose his job, had severe impacts on his family life, and has undermined his decades of work in recovery. So if you're thinking, hey, this is a lawsuit that doesn't really, this is a BS lawsuit, it sounds to me like he's arguing some serious stuff here. So that's basically what they're saying here. So real serious, addiction issues there. All right. So this is one of the ads there. Clean energy boost without the jitters, a social lift without the booze or hangover, a focus enhancement without the crash. And look at the advertisements they're selling here. Alcohol-free, caffeine-free, gluten-free, nut-free, dairy-free, no sugar added, plant-based, vegan. So here's another of their ads. Feel Free Wellness Tonic. And look, they've got a subscribe and save model. Delivery every 30 days. Yep. They say you don't have to worry about side effects. So, yep. As an ingredient in Botanic Tonics Feel Free Wellness Tonics, kava isn't addictive, but it's important to remember that anything that helps you feel good can influence some level of dependence. Think sugar or caffeine. So those are the comparisons. Now, caffeine is a lot more addictive than sugar. So these materials misleadingly omitted the effects of kratom. In reality, kratom is a highly addictive substance that activates the same opioid receptors like morphine. Um, yeah. All right. They talk about they hired hundreds of brand ambassadors to spread positive reviews about the product. Um, hey guys, do you wonder why I'm really cautious about doing sponsorships? Do you wonder why? Oh my God. Um, yeah. Lots of reasons why I'm super cautious about that. All right. Um, so they entered college campuses to target students who they say are particularly vulnerable. That they use targeted social media advertising to market to a particularly vulnerable population of individuals struggling with sobriety. Now, when they, assuming that they get discovery on this and that they get the ability um, to actually sort of dig into what the advertising plans are, they may get some information that says, "Hey, here was the their marketing strategy." We'll have to see if that's what's listed there. So we're gonna have to see if there was, if there's details about this. Um, Ian wants to be sponsored by my poops unicorns. My poops. Yeah. Life without alcohol allows you to feel free. So you don't drink alcohol. Great. Balance is key for a healthy life. Drinking botanic tonics helps you find focus and balance. Don't get hung up on hangovers. Botanic tonics will be your favorite alternative party drink. All the buzz without the booze. What emoji best describes this state of being? Um, buzz without the booze. Um, Mother's little helper. Tag a mom that could use feel free in her life. That's not making me happy. Um, that's not making me happy at all. Targeting moms trying to deal with, the stresses of kids and all that. Alcohol got you down. Cheers to feeling great not drinking. Use code DRIVE40. Hey, you know what'll get you off the alcohol? Opiates. Botanic Tonic also used popular internet memes to target individuals who are seeking sobriety or in recovery. So it's dry alcohol and your friends offer you alcohol. And there's the picture of the kid running away. It's dry alcohol and your friends offer you alcohol. Or versus it's dry January and your friends offer you feel free. Yeah. I feel like if you're taking kratom as like you're not really doing the sobriety thing there. Yeah. So pregnant and nursing moms who can't drink, good idea. Can you imagine like a pregnant mother who's like, well, I really miss booze, but this stuff says it's safe for moms. Like, Christ, that's awful. All right. Concentrated amounts. Do they have the elements? How much do they have? Okay, there's just a science picture. Here's a picture of science to show that we science. Yeah. Where's the actual numbers? Numbers. This is interesting. Because of the similarity between opioids and kratom, naloxone is used to treat kratom overdoses. Interesting. This one is also interesting. Botanic Tonics hired experienced operatives to lobby against government opposition to kratom. Ooh. The FDA attempted multiple times to classify kratom as a Schedule 1 drug. Now, I'm not a big fan of drug banning, but I mean, some restrictions on this is a good idea. To say maybe don't put it secretively in products. And Lady Heathy, I'm really sorry to hear this. My brother is hooked on that stuff, and he's in full psychosis. I'm sorry to hear that. Because yeah, I mean, this is causing real damage to people. So they say that they spent money to encourage that it wouldn't be scheduled. They claim that they formulated it specifically to enhance the effects. I don't know if that's the case. Independent contractors, I don't care if they use independent contractors. 7-Eleven made a marketing agreement. That's why they're being sued. So this is a display from 7-Eleven. Cool. He bought it from 7-Eleven, so that's why 7-Eleven is also being sued. Now, this is interesting. These are feel-free users who've made comments on TikTok and YouTube describing their negative experiences and explaining, and warning people. So I think that's these are, I'm afraid, going to be a little terrifying. So let's have a look at some of these comments there. Jess J, thank you for the member chat, saying, honestly, 13 and a half years opiate free. This is dangerous. Yeah, can you imagine you've managed to ditch opiates and then you get suckered into this? Like, that is, yeah, this is rough. So people's comments here, if only people like you were sharing this stuff a year ago. I'm on my third day without it, and it hasn't been much different than my alcohol withdrawals, cold sweats, anxiety. I can't get out of bed. I couldn't quit because I literally couldn't work without them. This is the most addictive and dangerous thing I've ever touched. The company has robotic responses. They're selling this to anyone and everyone, not keeping in mind people's history with addiction. They're selling it as safe and beneficial for everyone. I searched this because I've been progressively taking these more and more frequently, to the point that I'm now at about 2 or 3 a day, and having been feeling the flu-like symptoms you described. I was actually doing work with them for a while. I really enjoyed the product as it was relaxing my muscles. It made me feel really chill, but it also made me feel very weak and tired. I'm not eating good anymore. I tried to get off it, but I kept feeling like I needed it. If I didn't have one, I would get cranky. This video has helped me. Feels good to know that I'm not the only one that felt off about it. People taking up to 8 bottles a day. Somebody mentioning that they started using it because of a health podcast. And then it turned into 2, then 3, 6 a day. Warning, do not get tricked into this product. This product became a huge issue for me. I got up to 6 a day because I felt like crap if I didn't take it. Wow, right? This is terrifying. So 4 or 5 a day, most addictive substance I've ever touched. Somebody posting on Reddit saying, anyone else finding feel-free botanic tonics to be incredibly addictive? For the past 2 months or so, I'm up to 4, sometimes 5 a day with an occasional 2-day break. I have addictive qualities, including being sober from alcohol and trying to get sober from these effed up things. Anyway, I'm seeing that botanic tonic is being marketed as an alcoholic alternative. And let me tell you, no, in the days when I don't have it, I feel super depressed and all my body starts to tingle and I'm super restless. I just need to get it over with and suffer a little bit. Today is the day. F that nasty, brown, expensive blue bottle. Could this become a class action? They're looking to make it a class action. Yeah. So I've seen people being like, oh, yeah, they're just suing, just because they're looking to make money. It looks like they've got some serious claims here. I mean, assuming that this is made out, right? Unfair and fraudulent business acts or practices, because they're saying that there was misleading statements. False advertising, because it talks about the Kava and not the Kratom, and says that it's safe and whatever else. Common law fraud. Fraud is a big thing to allege, but yeah, it's I mean, they may have a claim here. A breach of implied warrant of merchantability, i.e., these things are not safe for use. Unjust enrichment. We talked about unjust enrichment. They got money. They shouldn't have got money. They shouldn't have that. So that's the first one. that is our first lawsuit there. The next one, and I'm just going to see if I can bring that up, because they're getting sued on multiple sides. So CC individually and on behalf of all others similarly situated. When you see that language of all others similarly situated, they mean we want this to be a class action complaint. Both of these are class actions that they're trying to launch. So defendant tells consumers that its feel-free products deliver energy, focus, and a social lift. The key ingredient in the products is kratom. What reasonable consumers do not know and what defendant fails to disclose is that kratom works on the same opioid receptors in the human brain as morphine, and its analogs, has similar effects and has similar risks of addiction and dependency and similar withdrawal symptoms. People don't know that they're basically getting heroin. Like, that is a problem. So, this is sort of the allegations here. They're saying that where they are, the second suit is that they're illegal to sell because they're adulterated dietary supplements. So condition of addiction and medical status, filing under his initials for the sake of personal privacy. So parties, if the product had included a warning about the addictive nature, would not have purchased it, has become very addicted. It is in the process of trying to wean himself off of it. New look, same formula. You can see the picture. You can see the marketing is really kind of aimed at, plant-based herbal supplement, plant-based tonic. Yeah, it's so let's see. Did they actually give us the dosages of this? I'm just trying to see if any of these have the doses here. I'm just, how much is in one of these? Yeah, it's not giving us the doses. All right. So yeah, this is another lawsuit or another aspect there. They're bringing a class action, similar claims, basically just saying, hey, oh my God, why are they doing this to people? This is really concerning because, quite frankly, it looks like there's a whole bunch of people who got into this thinking that it was safe and whatever else. And yeah, there's just no guarantees on any of that. So, all right. And yep, Julia, I saw your message there. I don't know what the context was, but if you reach out to me on Patreon, I will try to get back. Sometimes it takes me a couple of days. All right. So let's have a look here at another one that I wanted to look at, because there's lots going on in the news here. All right, let's just pull this up here as soon as we can. Sorry, I'm just struggling with my thing there. Did you hear about the case of a personal injury lawyer that went to his mom's to have dinner before he went and turned himself in for the Murdaugh type crimes, and then he killed her with a dumbbell? Oh, no, I hadn't heard that, and that is horrible. So that's awful. All right. Let's pull this up. So, in the matter of Part 3 of the Legal Profession Act, and in the matter of a hearing regarding the conduct of Evie in Hensakane Raga, a student member of the Law Society of Alberta. So they are, this is a Law Society proceeding just to determine what they're going to do about this particular person. So we got the hearing committee, and she was represented by counsel, which is a good idea at these things. So This is the story of how to stop being a lawyer before you even get to be a lawyer in Alberta. Somebody's asking a student member. A student member basically means that before you can become a lawyer, you've got to become you've got to do a year as a student. So that is you're sort of a trainee. That's sort of your training wheels aspect. So, yep. All right. So she advised the hearing committee that it was appropriate to refer to her as Mrs. Araga. So that's what we're going to call her. She immigrated to Canada with her family largely because of their need to find treatment for left out. That is not, not really relevant here. She was a lawyer in Nigeria from 1995 to September of 2013. And then she came to Canada. And so she wanted to become a lawyer here in Alberta. And she applied to become she was started in as the, articling, and then she applied to shorten her article. She basically wanted to say, listen, I'm a great lawyer. Like, you should just let me be a full lawyer. So she submitted a factum to the LSA's membership department as evidence of her ability. And then they investigated, and they determined that this factum was not actually her work. This is a really bad thing. Like, hey, Law Society, here is this evidence to show how great of a lawyer I am, and, that I'll be a perfectly fine lawyer. And they're like, yeah, about that. That's faked. What is articling? It is basically a year of apprenticeship that you do to become a lawyer here. And that, so you have to do that year in which you have the ability to do some things as a lawyer, but you're supposed to have supervision, but not everything. So, for instance, as an articling student, you can run a bail hearing, but you can't run a murder trial. It gets complicated into what you can and can't do. All right. So, during the course of the investigation, she lied to LSA staff and investigators, both orally and in writing, about preparation of the document. Compounding those lies, she fabricated what she represented to be earlier drafts of the factum in an effort to convince the LSA that she was the author. So, I watch Leonard French. Leonard French is, he is another lawyer on YouTube. I watch some of his content. It's good stuff. Check him out. I would love to do a video with Leonard French at some point, but he usually does solo work. Leonard French has a saying that I think is a fantastic saying, and it says, eat crow while it is young and tender, or else you will surely eat crow when it's old and tough. There are a lot of times when you might screw up, and screwing up, like, if you acknowledge that, then you might end up having, a better outcome than if you start BSing it. Aficionado, Leonard was my gateway drug to LawTube. I can tell you that Leonard French is one of the creators. There's basically two people whose work I saw on YouTube that let me think maybe I could actually do this. Maybe this would be something that would be fun to do. I had somebody who was telling me that I had to do YouTube videos for a long time, but watching their stuff, I was like, maybe I should actually look at this. Leonard French is my favorite copyright attorney. That's his tagline. Your favorite copyright attorney. What is it? Leonard French. He does good stuff. I like his stuff, and he was one of the inspirations that got me off my butt to actually try making a video. All right. In all, Misaraga failed to be candid to the LSA on 6 separate occasions between November 16, 2017 and February 2nd, 2018 regarding authorship of the factum. Painstaking and persistent investigation eventually produced undeniable evidence that she'd not written the document, and months into the process, she admitted to lying. Whew. I can tell you, somebody's saying, was Rackets the other one? I actually didn't know Rackets existed for a while. I was making videos before I knew Rackets existed. I found out Rackets existed because I was because I saw his Rittenhouse coverage, and so I started watching that. The other one was Deviant Olive is the other person. He's not a law. He doesn't do law stuff. He does like lock stuff, lock sport, security stuff, that kind of thing. So that was how I got into it. Those were sort of the inspirations there. All right. What blasphemy? Rackets is I didn't know he was out there, right? YouTube shows you some stuff. It doesn't show you other stuff. I didn't actually see any of Racket's stuff until I was already making videos. That said, once I got making videos, I ended up reaching out to him, and he was more than willing to have me on his channel, and that was fantastic. It was a big help. I really appreciate everything Rackets has done for me, and what is it? Kind of disappointed in Legal Eagle. I don't know much about Legal Eagle and what's going on there. So, also, Rackets specifically denies that he is the leader of LawTube. There is no. So, all right. So, on May 10th, they started an investigation. After reviewing all of the exhibits, they find her guilty of conduct deserving of sanction. So, they say that the appropriate sanction is suspension. Now, since this, she's had other problems with this. She's had other problems with the Law Society. And I will say, and yes, this is a good point. LawTube is a genre. Yep, Rackets loathes the concept of LawTube. And he's right about that, right? She's had other problems. This isn't the only issue that she's had. This isn't the only sort of problem on all of that, but she then fabricated evidence in the form of apparent drafts of the factum, redoubled the lies in writing, and only relented when confronted by a skilled, dedicated investigator with incontrovertible evidence. I'm wondering what that incontrovertible evidence is, right? So I'm wondering what that was. But this got her suspended. And so, this was sort of the initial sort of aspect there. Analysis and decision on sanction, integrity. I mean, how do you say you have any integrity if you're going to lie to the Law Society about this? This is one of the most serious things I can think of. And so let's sort of look here. Aggravating, mitigating, and neutral factors. They note that although she's a student at law, her conduct cannot be attributed to a youthful mistake, given her prior years of practice experience in Nigeria. She was already a lawyer elsewhere. She had to have known better. So, yeah. They say that this incident does not establish that she's ungovernable and has no prospect of rehabilitation. So, ultimately, what is the decision on this one? They impose a suspension of 12 months. So, you might be saying, wait a minute, didn't you say she got disbarred, like that she was prevented? Yes, she did. I don't actually have the full decision on this one, but she then, I can see if I can find it real fast, but she got into some further trouble on this one. She got into some further difficulties because she had some issues with the police, and those issues then led to apparently a false statement being made. She got charged with an issue with respect to I'm trying to find words here. I'm sort of losing it's getting late, so I'm losing my language here. So she got charged with what is the word? Obstruction or public mischief, I think it was. So anyway, there was, that aspect. She gets charged for that, and the Law Society, found that was again improper. So I'm just pulling up the decisions and outcomes here, trying to pull that up, see if I can find this real quick. Just see if I can track that down. Here we go, I hope. Sorry, I'm just trying to find the hearing report on all of this one, because they've issued a notice. It looks like we don't have the full hearing. Oh, no, I'm wrong. Give me a second. Sorry, folks. Little bit rough there. All right, so let's look at round two. Round two. So round two of this is, different people and, similar things about, the abbreviation of terms. But April 17th, police responded to an incident at her home. She was charged with public mischief relating to that incident. Public mischief isn't like mischief. They have the same word in them. Mischief is, I'm seeing requests to embiggening. So like mischief is when you damage property or prevent people from using property and so forth. Public mischief is misleading, like lying to police is sort of the common thing. So she had been suspended. She filed an application for reinstatement. And on review of the reinstatement application, they noted that it was incomplete and potentially inaccurate. So they requested some additional information. This is a problem, right? You're asking to be brought back in after the suspension. You want to be reinstated. You think you want to be about super, super honest. Whew. Okay, that's a lot of kratom. That's like a well into the active range. All right. It is alleged that she created a false eyewitness statement and provided such false statement to the police in the course of a criminal investigation, and that this is deserving of sanction. It is alleged that she provided false photo evidence in response to a Law Society investigation, failed to be candid once again, and breached an undertaking requiring her to preserve electronic data on her cell phone. So that's a problem. And they say the appropriate sanction will be determined at the sanction phase of the hearing. We don't actually have the report of the sanction phase, but we do have the notice that goes out. So, all right. So, they're sort of arguing all of this. Balance of probabilities. That's the standard. Witness credibility assessment. So failure to report. She failed to report her criminal charge is the allegation. And this is the criminal charge, on or about the 17th day of April, 2019, at or near Edmonton, Alberta, did with intent to mislead, unlawfully cause a peace officer to enter on or continue an investigation by making a false statement that accused some other person of having committed an offense, thereby committing public mischief. I just want to note here, if I get charged with a criminal offense for me, like anything, right? Impaired driving, assault, theft, trespassing at night, any of these things, if I get charged with them, I have to, I got to report that. I see Carrie Todd saying, let's get to 1,000 likes. We're at 1,200 likes, I think. So I think we passed that. But, if you haven't liked it yet, hit that like button. All right. So on January 14th, 2020, she submitted her application for reinstatement following a 12-month suspension. She answered no to the question of whether she was currently charged with an offense under an act of parliament where it was prosecutable either as an indictable offense or a summary conviction offense. That was the wrong answer. That was the wrong answer. It's not hard. You say yes if you are charged with an offense, right? Yeah. And I can tell you, so at one point I screwed up. I had a file where I screwed up, and I went into court and I told the court, like, hey, here's what happened. The court was like, whose fault is it? And I was like, that was my fault. And the judge sort of did a stop and went, oh, Mr. Runkle, I was going to yell at you, but if you knew that if you're acknowledging that this is your fault, then we're okay. Like, we're good. It wasn't a serious screw up. It wasn't a big, thing, but it was, just, I should have gotten something, a disclosure request in. It didn't harm my client or anything like that. It was just like a minor thing. She submitted a letter that stated, during the 1 year of suspension, I have read all of the rules of the Law Society, the Legal Profession Act, and the Alberta Law Society Code of Conduct. They are now my guiding principles for a better practice. Would that was true, because, yeah. Now, on March 25th, 2020, the public mischief charge against her was stayed. It was killed. And then on September 22nd, 2020, after that, she notified the LSA in writing regarding the charge, only after it went away. So that's a problem, because, she filed this declaration saying that she made it conscientiously, believing it to be true, and knowing that it is the same force and effect as if made under oath. Guys, if you're making a statement under oath, you really don't want to have that in there. Here for years, I see your question. I will get to it. It'll be funny. So yeah. She got herself in all sorts of trouble. So in early September 2020, KO, a practicing lawyer who was retained by Ms. Zaraga as legal counsel in the public mischief matter, her legal counsel advised the LSA of the public mischief charge, and also advised her that she must report such charge to the LSA. Her legal counsel knew the ethical obligations. So, yeah. So then she acknowledged that she'd screwed up. She said, I am sorry for not reporting this earlier. Like I said, I erroneously assumed that since I was the victim of the assault, I did not have to report the incident. Kindly accept this as my notification of the incident and its discharge to the Law Society. So Section 105 also stated that even when it is discharged, I ought to notify the Law Society. But I mean, she was charged. Yeah. So this is, she added that she never went to court with her lawyer, and that her lawyer had an early resolution with the Crown prosecutor. Yeah, this charge ended her career. She retained KO, a practicing lawyer and former classmate, regarding her promise to appear. Now, it's actually really common that a lawyer would not, or that you wouldn't appear on your own. Really common. And you're only required to appear for certain things. And one of the things that, one of the reasons to hire a lawyer is that your lawyer can make a lot of appearances for you and thereby save you from having to do it, right? Because otherwise you might have to take several days off work. So, and Laura Christine, I first came across Ian during the Depp trial when EDB chatted with him. The Depp trial was a lot of fun, although it also nearly killed me, I gotta say. But EDB, being able to chat with EDB was fantastic for all of that. All right. But she had January 2nd correspondence, January 17th correspondence. She says that she didn't answer the question 17B because she didn't think it applied to suspended students. That makes no sense. She believes she was not currently charged based on her discussions with the lawyer that the charge would be stayed. Also reflects a very poor understanding. She said that she practiced as a lawyer in Nigeria from 1995 to 2013 in various settings, including as a criminal prosecutor. Whew. And that she completed her articles in the CPLED program and as a student at law in Alberta. Quite frankly, if she was a prosecutor on a case that I had run, I would now be asking for some charges to be reopened, to be looked at a second time, because if she is, if you're willing to forge up evidence here, that is, really concerning. All right. So she says that she didn't have a duty, but when you look at the rule, it actually specifically states student at law, applicant for readmission or readmission. It's real clear on that point. And she said she'd read it. So she says that she had an autonomous belief, but that doesn't make any sense given the law, which she's supposed to be good at because she's trying to be a lawyer. So they had several opportunities, skipping ahead. So they find that she had a duty to report. She didn't report, so she's in trouble on that. So, yeah, that is really concerning. The committee, in rejecting her explanations for failing to report, finds the following. 1, the rules apply to her as a student at law. B, her explanation makes no sense. She knew or ought to have known that she was not only a complainant, but also charged as a defendant with the public mischief charge because she was a lawyer for however long. She can't just her explanation that she believed that it would be stayed is unreasonable and illogical. She filled out the application on, January 14th, and they didn't agree on the terms of the stay until March 2020th, and it wasn't granted until March 25th. So how would she know about that when it wasn't actually the case? So they find that she had failed to report it. False witness statement. So this is serious. She reported that she had been assaulted by one of 2 males who had entered her home, the alleged assault, and handed a copy of it. And SB would have been the police officer, I guess, questioned her regarding the eyewitness statement during their interview of October 30th, 2020. SB observed a number of similarities in the handwriting style of the eyewitness statement to various documents handwritten by Ms. Araga that were in the LSA's possession. SB presented 15 examples of handwriting similarities between the eyewitness statement and the documents written by Ms. Araga. Ms. Araga repeatedly acknowledged similar and in some cases identical writing in the eyewitness statement, but also denied authorship of the statement. At one point she stated that's why they were going to charge me for mischief. So she denied that she wrote that statement. She gave explanations regarding finding the eyewitness statement in her mailbox. She said her husband gave it to her. When her asked if her husband would give a statement to that effect, she said they didn't ask him. The eyewitness would not know her mailbox number was number 5, but the post office staff could put it in the parcel box in the community mailbox. She didn't say it in the mailbox. She saw it on the mailbox. She denied having told the police that she saw the eyewitness statement in her mailbox and said that her words were, "Look at what we saw in our mailbox." The eyewitness statement was folded, marked with the word attention, and stuck to the outside of the mailbox with a sticky substance like gum. She stated that she told the police that her husband or anyone else, or she denied that she'd seen the eyewitness statement in the mailbox. So a number of different, so she's apparently reporting that she'd been assaulted. Oh, I think SB was the LSA investigator. Okay, fair enough. She's saying she's been assaulted. There's this apparent eyewitness statement, but it looks like she wrote that. So she was questioned about it. She says she didn't know who the author was. She said she didn't know who gave her the statement. She received it with other pieces of mail, and that her husband should not be brought into this matter. Don't bring him in, because he's going to call you a liar. Like, don't bring him in. And Fresh Donuts, you are exactly right. These types of situations reinforce public perception issues with our profession. It's important we deter this kind of behavior. Yep. Evidence of KK. He was a constable with the EPS at the time, responding with her partner to a break-and-enter complaint. Now in child protection, but she referred to her notes and narrative. While at the home, she gave her the eyewitness statement, which she said had been found in her mailbox. She seized the evidence, or the note, as evidence. She testified that she asked Ms. Araga for an explanation regarding how the eyewitness would know which mailbox was Ms. Araga's and how they could place the note inside. KK stated Ms. Araga could not explain how the eyewitness would know which mailbox to put the statement in. She stated that the note could have been folded and slipped into the mailbox through a narrow gap in the mailbox door. This would be apartment mailboxes, which are really kind of, they're like a wall of mailboxes, and you open the one for your apartment. After leaving Ms. Araga's house, KK and Constable F examined the mailbox and attempted to insert the eyewitness statement as described by Ms. Araga without success. They took photos of the mailbox at this time. Although the committee is not aware of the outcome, KK testified that on April 18th, she contacted Canada Post to follow up the possibility that the eyewitness statement had been found by Canada Post staff and inserted into Ms. Araga's mailbox by them. And IB is now an LSA investigator. So they questioned the authorship of the eyewitness. Basically, they determined that... God, this is funny, folks. This is hilarious in terms of just how badly... This is such a terrible aspect. So IB, the investigator, looks at the original anonymous eyewitness statement, the original police witness statement by Ms. Araga, dated April 17th, original police witness statement by Ms. Araga, dated April 18th, copies of additional writing samples. Folks, you can't make this stuff up. It is just too freaking hilarious. Factum notes, draft 1. Factum notes, draft 2. Signed declaration, student forms and agreements. You know what the factum notes, draft 1 and draft 2 would be? Those have got to be the faked up drafts that she submitted to try to get, that got her into trouble in the first place. This factum is destroying, like, is hunting her down like some freaking cruise missile. It's yeah. So on February 2nd, they advised LP of an email of package which included the original documents and writing samples, and they discussed the handwriting on the eyewitness statement with Ms. Araga. She recalled that Ms. Araga generally acknowledged that her handwriting of the eyewitness statement were similar and at times identical, but stated that she did not write the note. She's not even good at crime. Like, I am so glad that this person is not going to be anybody's lawyer, right? This person, like, these allegations basically say somebody was a time bomb waiting to happen. So this person did handwriting analysis for comparison purpose, prepared a forensic report, which included a narrative of the data and observation, and they demonstrated the relatively unique pattern of similarities that exist between these two groups of notations. And they provided all that. So the eyewitness statement contains a number of features which indicate that the notation was more slowly and deliberately written, likely as a form of intentional disguise. The specimen writing does not include many of the words or letter combinations that are observed in the questioned anonymous notation. Many of the specimen documents are reproductions. These are the limitations there. All right. So, but they say that there were considerable unique similarities that were not coincidental. And yeah, basically they're the same person. So, and they say that, in the interest of objectivity, there's a minor degree of doubt. But the likelihood that it was produced by somebody else is considered to be extremely remote. My God. So then she says, I returned home. I was given some letters, including the eyewitness letter paste with a light gum on the general mailbox. I never told police it was kept inside my locked and sealed inbox. I was not home when police came to the crime scene. I was not the one who picked up our letters on that day. So she's now saying that the police are lying. I mean, sometimes police lie, but why would the cops lie about this one? She testified that her husband gave her the eyewitness statement, and she denied authorship. Yeah. I think it's reasonable to conclude that the LSA was generous here, given indicia of an intent to deceive. Yep. Absolutely. She reported that she'd been assaulted by one of two males who'd entered her apartment. So I'm guessing that basically this eyewitness statement basically says, here are the people who attacked. The eyewitness statement on its face is questionable. There's a highly detailed information, time, description of a man, a license plate number, but no contact information for the witness. Circumstances by which the eyewitness statement was supposedly found and the explanation given by KK are improbable. They couldn't make it happen the way they were doing it, and so forth. So, and the other thing is, if the police were making it up, why would they actually test whether a note could be inserted in the mailbox and make notes of that? Right? So, all right. So do you think that they're going to find that this is, that this ground is made up? Yes. So let's skip ahead here because there's lots of pages on this. Given the above, the committee finds that it's proven on a balance of probabilities that she created a false eyewitness statement and provided to the police in the course of criminal investigation. Like, this is false evidence, right? Ooh, false photo evidence. So she submitted a number of photographs purporting to show the disarray in her house on April 17th caused by the alleged assault. 9 photographs of the scene, which had been taken by her son. 2 photos of the scene taken by KK on the date of the incident depicted the following: part of a sofa with an accent cushion and a bunch of stuff. Ms. Araga's photos included the following examples of disarray and inconsistencies: flipped over rugs, small china cabinet, items on top knocked over, overturned kitchen chairs, thermal mug and telephone on the floor, other things knocked over, missing, or added, or whatever else. So they also revealed inconsistencies such as 2 photos of the same area with differing items on the sofa or floor, or items in a different orientation. So she took pictures, like multiple pictures, and some of the pictures showed one thing and other pictures showed different mess, and she's saying it's all the same mess. What am I talking about? I'm talking about a lawyer who was trying to be a lawyer and didn't become a lawyer. Yeah, hate when intruders flip over my area rugs. I mean, there are reasons why they might check under the rugs, but it makes no sense here. The most obvious fake crime scene ever. And yeah, Amber, is that you? She staged the mess. Yep, that's the allegation here. So they questioned about the discrepancies. She insisted the police could not have taken the photos on the day of the incident and that her home had been cleaned and rearranged after her son had taken the photos. So she was unable to answer questions about it. She said that the police officer took the photos on the morning of the day following the incident after the house had been rearranged. The carpet was different because the original had been given to her son. The house appeared on disarray on April 17th, 2019 after the incident, but she'd cleaned it up later. Their house phone fell to the floor with the battery open. that her son had taken the pictures, but also noted her son was 16, and her husband was prepared to testify that they didn't take the pictures on April 17th. Okay, so like this is some chaos, right? So arguments and analysis and decision. Let's go to the decision on this one. Survey says they find that the photos taken by the police officer are the true record of the state of the events, and that her photos were staged and represent false evidence. So provided false evidence photos. Whoops. I love this one. That rug really pulled the room together, man. If you haven't seen The Big Lebowski, you got to see The Big Lebowski. Random items tossed about to make it look like there was a struggle. Where have we seen that before? Yep. Whew. Failure to be candid. Basically, all of this stuff she lied about. Given that they already found she lied about it, they're going to find that she was lying about it. So was not candid throughout the investigation. Cool. Breach of an undertaking. She said she would provide electronic data on her cell phone and would refrain from deleting any emails, text messages, etc. Let me tell you guys, the Law Society has incredible power. If the Law Society alleges that I have done something wrong, they can demand my phone and search the hell out of it, which is a really good reason to not do things that would get the Law Society interested in this. So, in response to Ms. Araga's hesitation to surrender her phone immediately due to concerns regarding the privacy of data on the phone that was unrelated to the investigation, they agreed to accept her verbal undertaking that she would refrain from deleting any emails, text messages, photographs, electronic documents, or other material that is in any way related to this investigation. They trusted her to not delete those things. They trusted her to be allowed, essentially, to delete other stuff because they might be saying, like, listen, maybe she's got some personal photos on that, right? Maybe she's got some pictures about, her and somebody else. So they're saying, like, listen, we're going to let you keep your phone. We'll let you delete, or not share those details. F her, because as a result of all of this, the Law Society is probably not going to give anybody else that break, right? Anybody else who's getting charged with, who's getting accused of this, they're going to be like, no, you provide your phone right now. And we don't care if you got pics of whatever on there. If you got pictures of your wife, you got pictures of yourself, you got doesn't matter, your fault. She's made things worse for everybody. Yeah. Too bad. They're going to the Law Society. Law Society's going to get to see the pictures. Yeah. So, and then she provided responses to the undertaking, including how my son gave me the photographs on 18th November. My son reminded me that he printed them off in 2 copies and gave me and his father at the same time each copies. The photographs attached to my email were from printed pictures handed to me by my son. I scanned them myself via email on November 18th, 2021. You don't think that people can recognize the difference between a scanned photo and that? Could the Law Society demand your phone if there was protected client information on it? You bet. You bet they could, because they're going to say, we can treat your materials properly. So, yep. No electronic photographs currently in the possession of my son. Original electronic version of photographs cannot be provided because the phone used to take the photographs have been stolen. Man, she's got all of this, like, she's got all of these super convenient excuses for why she can't do any of this stuff. Original email of transfer of these photographs to KO was from my husband. It was not me that sent to KO. I gave my printed copies physically to my lawyer KO in his office. I only kept electronic copies of all the photographs on my email for my personal records. And that is what I photographed to you. Her lawyer freaking hates her. Her lawyer freaking hates her if she's throwing him under the bus too. So on March 30th, they took possession of the phone. The pictures viewed during the meeting no longer appeared on the phone. She says that the phone was the same phone, that she was the one who opened the phone pictures to views, that her cell phone had not been used to take pictures, that she'd scanned photos to her email, that she did not have another cell phone. So, yeah. After promising not to delete the pictures, they're saying, hey, deleted pictures. Yeah. All right. Evidence of KR. KR is a digital forensic investigator. The Law Society's pissed. If I just want to say just how pissed the Law Society is. And this is a good point. The Law Society only has this power over lawyers, correct? They can't take non-lawyers' phones. You know how pissed off the Law Society is? Well, first, they've had to do this investigation into that factum that was fake. They've had to hire a handwriting expert. They've had to hire a forensic, like a digital forensics expert. They're freaking pissed. They're spending all the money on this. And you know who gets to spend all the money? You know who ends up with a bill for all this? Oh, right. It's going to be her. It's going to be her that ends up with a bill. So specific conclusions in the report include the photos that had been attached to the email could not be found in the photo gallery in their original form as when they'd been taken. I found depictions of the original photos originally stored or individually stored in the sent items folder of the WhatsApp application. I've concluded that the original photo or a version of the photos used by WhatsApp had existed on the device as of at least March 26, 2021. I can further conclude that the photos were then deleted from the device as no depictions were found on the device. Because of the limited device access, I was unable to recover them. I cannot know if there are more photos deleted from the device than the ones noted. Now, I just want to look at the... when was that undertaking given? When was that undertaking? I'm just scrolling back. March 26th, she gave an undertaking not to delete any emails, etc. When does she delete them? March 26th. Sometime after March 26th. Whew. That's bad. I'm just going to say, if this was my client, I would be seriously unhappy. Seriously unhappy. Yeah. New members, the TOTC prep stream is expected to come down tomorrow. I will leave it up until like midnight tomorrow. And then I will take it down. Ang Torres, thank you for making it. I'm glad to see you. I know you weren't sure if you could make it. We've been going for a while here. So glad to see you've made it here. And I see Twitter is always really bad at messaging. All right. Evidence of Mizraga. So more lies, basically. My phone was taken from me. The text messages in the photo were in the phone. The police took from me. They never looked at it or did not print all the photos out. During the March 26th, she confirmed that she'd been sent the photos. She asked that her son resend the photos as she had a new phone. But since 2019, I've not changed it, so the details is there. So I now send it to KO. Ugh. A lawyer must not give an undertaking that cannot be fulfilled and must fulfill every undertaking given and honor every trust condition once accepted. So let's talk about undertakings. Undertakings, like if I say to Joe, I say, "Hey Joe, I will mow your lawn tomorrow." That's not a big deal, right? And if I don't mow the lawn that day, at the end of the day, it's like, well, stuff happens. Oh, wait, we're past 2 hours. Shit happens. And Ang Taurus, thank you very much for 5 gifted memberships. Much appreciated. But yeah, if I say I'll mow the neighbor's lawn tomorrow and I don't, shit happens, stuff breaks, right? But if I say I undertake to mow my neighbor's lawn tomorrow, an undertaking is serious. An undertaking is I promise to do this and I know it will have legal consequences for my ability to practice law. So you don't give an undertaking unless you're freaking serious about it. I can tell you I've had to give undertakings before, and when I've had to give undertakings, they are the first freaking thing I do. Like, we get that shit taken care of right away. All right, so she gave an undertaking, and she says she didn't disobey it, but yeah, the committee finds that she didn't follow the undertaking. In light of the totality of the evidence, the committee cannot rely on Ms. Zaraga's explanations, as her explanations were evasive, inconsistent from one conversation to the next, are contradictory to each other, and often implausible. So she can't act like she's not only a liar, she's a terrible liar. So failed to fulfill an undertaking to the LSA. So yeah, concluding matters. They are deserving of punishment, and they're saying that they will reserve decision on that. They'll say that they've said that they'll set the sanction hearing and that there will be a decision on that. All right. So what happened at that survey says this: termination of registration. Termination of registration. This is the result. Was that an undertaking when the judge ordered you to attend your client's AA meetings? It was not. I did not undertake to do that. The judge directed me to do that, but I didn't undertake to do that. On May 10th, a hearing committee of the Law Society of Alberta terminated the registration of Evie or Ms. Zaraga, a student at law, effective immediately. Pursuant to the Legal Profession Act, termination of registration of a student at law is equivalent to disbarment. Therefore, Ms. Zaraga is no longer eligible to be enrolled as a member of the Law Society of Alberta. They found that Ms. Zaraga's conduct was deserving of sanction on 5 citations, all of the ones that we mentioned. Conduct deserving of sanction is defined in the Act as conduct that is impermissible or incompatible with the best interests of the public, including members of the Law Society, or conduct that tends to harm the standing of the legal profession generally. Now, she's got to pay costs. Costs in the amount of $110,455.84. I love the 84 cents. The 84 cents is the real, like, fuck you cherry on the go fuck yourself cake here. This is, yeah. And referred her conduct to the Minister of Justice and Solicitor General pursuant to Section 78, sub 6 of the Act. What does that mean is not only did they say we are disbarring you, they are also saying we are recommending to the government that they pursue criminal charges. And somebody pointed out some really important things. If she was in Canada on a visa or, any immigration status short of citizenship, this could affect that too. She could absolutely be at risk of getting disbarred if she's not a citizen. And we know she's an immigrant. I don't know if she ever got her citizenship. And so can you imagine coming here to, you come to another country as an immigrant, and it was noted that she was in Canada to get medical treatment. And then she gets bounced. Like, whoops. What happens if she doesn't pay those costs by May 25th, 2025? They will actually pursue them they'll pursue a civil judgment. Deported or disbarred? She's disbarred now. She could actually get deported. Like, this is if she gets charged, she could get deported on this. All of this defies belief, right? All of this starts up because she wanted to get through articles a little faster. It's a year. I know articling sucks, but it's a year. Like, just swallow it and live with it. I had to do a year of articling. Now, admittedly, I wasn't a lawyer for, nearly a decade in another country, but and then this fake statement, fake photographs. This is absolutely freaking insane. It's just, it defies belief. All of this was just for the smallest, the most trivial gain. I don't understand it. I just don't. But I will say, glad this person's not in my profession. Get out. Yep. Bounce. That's kind of my take on that, all of that. So, and I just want you to note this. They put this notice out to the public, all active lawyers and students at law, all inactive lawyers, all executive directories of other law societies in Canada, all justices of the Court of Appeal and Court of King's Bench, all justices of the Court of Justice of Alberta, all applications judges, all clerks of the court. This message that she's been disbarred goes to everyone she knew in the legal profession, every judge, every justice, everybody. I found out about this because I got this in my email to say, we have disbarred this student at law. I got, so somebody was asking, could she apply somewhere else? Like, could she go to British Columbia or Ontario or whatever else? Well, we know that she's got, from this past record, she's got a habit of leaving things out of her, law society application. So let's say she makes an application in British Columbia and she leaves out that she was disbarred in Alberta. Well, they're going to check and they're going to be like, oh, right. She been disbarred in Alberta, and then they will bounce her. This is like scorched earth. And can you imagine how freaking humiliating this is? You're a young lawyer, you're an articling student, you're, whatever else. And, your friends, you've made friends in the profession. I can tell you those friends probably not answering her phone calls. It's probably gotten real freaking lonely for her in the legal profession. And, I don't think she's ever going to be able to become a lawyer, even, let's say 10 years from now, she says, you know what? I got better. I learned. They're going to say, you said that the last time. You said that the last time. So they have burned her to the ground. And you know what? Actually, that's not true. She burned herself to the ground because the Law Society, it's not their fault. This is the correct. I think this is the only correct decision. I don't think that there was another correct decision to be made here. It's just that she absolutely needed to be scorched earth. So I'm wondering who she was articling for, because she was apparently articling for somebody. I'd ask around in the legal profession and be like, hey, whose student was she? But I bet nobody's going to be like, mine, I volunteer. So, yeah. Somebody said, will she be deported to the U.S.? I don't think so. If she was deported, she would probably be deported to Nigeria. Now, I don't know. Cynically speaking, if she is facing criminal charges that might result in deportation, maybe she would look at going somewhere else. Like maybe she would look at leaving the country, but she's got an ethical and criminal requirement to, to attend. How often does the Law Society send out letters like this? Every time somebody gets disbarred. And in fact, if you get suspended, they also send out this letter to say you've been suspended. Even if it's for a month, they send out this letter. And the reason why is that everybody knows that you are suspended, right? So that you can't sneak in and do legal practice for a bit. That's why they send that out, is just that everybody knows and so forth. I see Neo-Renaissance. She could practice illegally off the books. I can tell you that's a real bad idea. There's a lawyer here who got disbarred. He was actually my articling principal, like the lawyer I articled under. He got disbarred, and then he got in trouble for practicing law sort of under the table there. And for the kids, thank you very much for the member chat there, saying never a dull moment with you, Runkle. Well, thank you. I try to be interesting. I see, dude, how could she F up in Canada? Like the nicest place, and she can't make it work? I mean, this would have been so easy to avoid. What did she do? So first, she submitted a false report or a false factum to say I'm a good lawyer. I should be able to, skip articling. And then they found out that was faked, that she didn't actually write it. And then after that, she basically provided a false statement to the police and false statements to the Law Society. Darn Bush is still attacking Runkle. I'm still finding little spines from that damn thing. If you don't know the story of that, there's a burr bush outside, and I tried chopping it down, and it just sprayed me with these little spines, and I'm still freaking finding them, and it sucks. After a bit, they're going to start to probably like infect and swell up, and that's going to be freaking miserable. What are the chances she did the same sort of stuff in her own country? I don't know. I mean, I hope that lawyers in Nigeria are generally ethical and honest, and that she's that she's an aberration. That's my assumption. But she was a prosecutor. Oh my God. She would have sent people to jail. If I'm sitting in a jail right now and she's the person who sent me there, I'm going, whoa, I want another hearing. I need to know that the evidence that was used to convict me was actually evidence and not just something that was made up. So, yeah. Did I try the sandpaper suggestion? I didn't try the sandpaper suggestion. I don't want to sandpaper myself. I did use some duct tape, and the duct tape I don't think helped all that much. So, yeah. All right. Those are seeds, Runkle. You're going to find some more growing soon. I don't like that. All right. So let's look at, we got some super chats here. Time to an addict like me. Love to hear this. I was prescribed Xanax for 15 years. My shrinks won't give it to me anymore. So I started drinking after 23 years. I'm sorry to hear that, Time. I hope everything works out. Thank you for sharing, but I'm sorry to hear it. This one I will get to in a moment here. Kyle Fox. I think I found you through Deviant Olaf. Deviant is a great guy. I love his content. He's one of those guys that's just one of the things that actually really got me hooked on Deviant Olaf's content is not just I started watching it honestly because I was looking at some of his stuff just to try to figure out like I was trying to figure out a criminal case. I was actually watching his video to try to figure out what my client had actually done. That was kind of what I was trying to track down. But then I saw that he had videos where he was like talking about like a package to give to the to homeless people and stuff like that. And there was compassion there. There was stuff like that, and that made me think, yeah, this is a guy I want to watch. So I watch all of his stuff. I'm a big fan of Deviance, and I've had the opportunity to meet him, and he's a great guy. Katara, thank you very much for the super sticker. Much appreciated. Time saying, so if she gets deported, will that be to the U.S.? Probably not. It would be deported to wherever, like if she's not a citizen, she would be deported to wherever she has citizenship to. So that would be where she'd go. Now, this is a fun question. Have you ever been seriously dressed down by a judge? What happened? So I've had a few dressing downs. None of them have been that bad overall, because I haven't screwed up that bad to get chewed out as bad as you could. But so here is a story of me getting chewed out by a judge. And this one was bad. I got ripped into for like 45 minutes. He was really ripping into me. And then afterwards, the judge had to apologize. So I went to one of these rural courthouses, and I was there appearing. My client had a matter. It was a fairly minor matter. Crown and I were still working on a resolution on that matter. We actually got that matter resolved that same day. My client was like this old farmer who they were saying he had guns and his license had expired. This is not going to narrow it down because the number of old farmers whose license I've expired that I've represented is probably north of like 50. So anyway, I'm there and I'm trying to, I'm talking the Crown into not sending my client to jail, which ultimately we did. It was a fairly sort of easy call on that one. But let me just pull this down. So I get there and I'm talking to the clerk, and the clerk was going, we're in shit. And I was like, what? She says, well, duty counsel never showed up today. Now, what duty counsel does, they're a lawyer that is there that basically helps out anybody who shows up to court who doesn't have a lawyer, or anybody who's in custody who doesn't have a lawyer but has a court appearance. So as duty counsel, you help out random people who walk in. You help out all the people who are in custody and are not represented by a different lawyer. And you also might help out the court in various ways. In the sense of like maybe a lawyer missed their appearance and the court might say, listen, we don't want to send a warrant out for this guy's client. Duty counsel, would you be willing to reach out to this lawyer, tell them they screwed up and tell them they've got another court date? And we're just going to give them that break. So, duty counsel does all sorts of things. And the clerk was like, duty counsel's no show. And I'm like, give me the docket. And she's like, what? And I'm like, just give me the freaking docket. I know you weren't saying duty counsel no show just to make conversation. I'm going to step up because the other lawyers here aren't. So give me the docket. I'll do it. Right. So she gives me the docket and somebody says duty counsel does not pay. You do get paid for being duty counsel, but it's not great money. And I didn't know if I was going to get paid for this because I'm just volunteering. Like, I'm just covering it. Like, we're just going to do it today. And then I was like, I'm going to have to call up legal aid and be like, hey, because legal aid provides duty counsel here in Alberta. And I was like, hey, regular duty counsel didn't show. I did it. Will you pay me? And to be fair to legal aid, they paid me. So I will give them props for that. And yeah, this is correct. You work too hard for too little money. You hustle as duty counsel, and you get paid not a whole lot. So I'm going and I'm hustling around and I'm running all of this, I'm getting all this stuff done. And the clerk says, Mr. Runkle, the judge wants to see you in the courtroom right now. And I was like, but I'm still talking to clients. She's like, no, now he's mad. I'm like, okay. So I step away from interviewing clients and I go into the courtroom. And the judge is like, Mr. Runkle, so nice of you to grace us with your presence. Which is the kind of comment that is just like, oh, shit. This is not going to be good. So he says, please, come on up. You're top of the list. And I'm like, don't like this. So I go up there and he's like, Mr. Runkle, I understand your duty counsel today. And I'm like, yes, I am, sir. But, and he's like, I didn't ask for a but. I asked for a yes or no. And I'm like, but, and he's like, no, Mr. Runkle, I'm talking. And the clerk is trying to interject. The clerk is going, hey, sir, you need to know. And he's like, nuh-uh, I'm talking. And he says, what time did you arrive at the courthouse today, Mr. Runkle? And I'm like, well, sir, I arrived at like 9:45 because court in that courtroom started at 10 a.m. And I'm like, but, and he's like, I don't want to hear any explanations. Do you know that as duty counsel, I expect you to be here at least at 9 a.m.? Quite likely earlier at 8 or 8:30, because you are expected to be here getting to things, because we have a lineup of people in custody and we expect this courtroom to proceed in an orderly fashion. You cannot breeze in just before court starts. And I'm like, sir. And he's like, I don't want to hear it, Mr. Runkle. So he's just ripping into me. He's like, this is improper. Like, this is, I have never seen such a negligent duty counsel in my courtroom. Like, just freaking dropping bombs on me. Finally, after a lengthy period, he says, Mr. Runkle, now I would like to hear what you have to say for yourself. And I say, sir, I acknowledge that I arrived here at 9:45. However, I was not scheduled to be duty counsel. I volunteered to be duty counsel because duty counsel had not attended. I don't even know if I'm going to get paid for this. It might be that I'm just doing this pro bono. And he looks over to the clerk and says, Madam Clerk, is that correct? And she goes, yes, I was trying to interrupt to let you know. And he's like, Mr. Runkle, if I'm ever inclined to yell at you again, please remind me that you have a get out of jail free card. All right, what's top of the list? And that was the apology, was just, you have a get out of jail free card for the next time. And yeah, this same judge gave me a partial chewing out because there was a preliminary inquiry that I arrived late for. And this judge, as you can already gather, is super keen on people being on time. So I got there at 10:15 for a prelim that was set to start at 10. And he starts with, Mr. Runkle. So, it's important to be here on time. Now, I was keeping in mind that whole get out of jail free card thing. And I was going, I don't know if he even remembers this. And he says, Mr. Runkle, why were you late? And I said, well, sir, I was driving here, and as I was coming here, I got a phone call, and this phone call was indicating that one of my matters in Edmonton was going sideways. It was going awry, and my agent needed some additional instructions. And so, because of that, I was on hands free, but this was going to be a little more distracting. I pulled over to the side of the road to have a discussion with my agent. We worked out what the instructions would be, and then I got on the road, and as a result, I'm late. And he says, "Mr. Runkle, are you leading me to believe that you pulled over on the side of the road to have a conversation rather than just driving while talking?" And I said, "Yes, sir." And he said, "Then I have no further complaint with you. Every day I see people on the roads on their cell phones driving dangerously. If you were sufficiently, if you're, if you were taking care to be on the side of the road and not endanger the public, I support that entirely. And we have no further issues. Are we ready to proceed on this matter?" And the Crown and I had already had a brief conversation and worked out a deal. So we were like, kind of, we're doing a guilty plea today for a lesser included. So I just was like, whew. But yeah, the judge was just like, okay, if that's the reason why you were late, we're good. I got no problem with you. So a couple of times I sort of got minorly chewed out, but it could have been way worse. So yeah. All right. I am going to, have I ever had to cash in on that get out of jail free card? I haven't, and I don't actually know if that judge is still practicing. But yeah, I was kind of horrified. I was like, oh, this is going to be rough. So yeah. And Melissa Harden, thank you very much for the $5 super chat there. My brother got convinced to go skydiving. The minute he jumped out of the plane, he realized it was the worst mistake of his life. Yeah. It's like a minute to get to the bottom, and then you got to wonder. Did I do the fish story? Which fish story? Because there's several fish stories. Kristen M96, remind me which fish story, and if you can remind me that one, I can go through it. Otherwise, we will wrap up, because we've been at this for almost 5 hours, which is a long time. I'm probably after this going to go and do a little bit of work in the leather shop, and then after that, shut down and head to bed. Oh, cheating in the fishing competition. I haven't done that one yet. Ooh, that is a good one. All right. So let me just pull that up. So they were sentenced, and I can just pull up the article here. Boop. Embiggen. And add to stream. So people are saying, how do you cheat at fishing? So the way you cheat at fishing is that they were in a fishing tournament, and the fishing tournament is done by weight. So you bring in however many fish, and then they weigh them at the end of the day. And however much they weigh is, that's who's the winner, whoever brings in the most. Oh, and people are telling me swoop. All right. I didn't hear the swoop. Did you guys hear the swoop? Hopefully you guys heard the swoop. I got to restart my audio engine, I think. Did you guys hear the swoop? Okay, good. Hopefully you're hearing me. My audio has cut out entirely. So I don't know what's going on with that. Just trying to see if I can actually hear anything. All right. I'm just trying to fiddle my audio to see if I can actually get to hear anything. All right. Restart audio engine. All right, I got no audio. We'll just live. All right. So because of this, these guys were, what they were doing was that they were putting weights in the fish. And so they got caught. People were cutting open the fish and pulling out these weights. And when they were pulling out these weights, there's a video of it. And the other fishermen there were pissed. They were seriously mad. It was looking like it was going to result in violence. And the other thing, and this is funny, they were also putting fish in the fish. Yo, dog, I heard you like fishing, so we put fish in your fish so that you can cheat while you fish. So, yeah. All right. So they pled guilty to felony charges of cheating and misdemeanor count of illegal animal ownership after they used weights to make their catches appear heavier at this tournament. Now, you might be saying, who gives a damn, right? Who cares about this this issue? They won boats. They got tens of thousands of dollars out of this. They got huge money out of this. So this is not trivial. And if you're a fisherman, who came second and didn't get a brand new fishing boat because you came second, you're pretty pissed about this, right? So, yeah. So the weights showed up under the scales while on the scales. Oh God, that's a truffle hound worthy joke though. So let's sort of look at what they ultimately got here. They both had to pay a $2,500 fine, which could be reduced if they make a charitable organization donation to a charitable organization donated to fishing and children. They also, so that's the minor, they got a $2,500 fine. That's nothing. But they also had their fishing license suspended for a maximum of 3 years. Okay, 3 years. And they had to forfeit the boat they used in the tournament, which was valued at $130,000. The boat is the real consequence of this one. And they note the defense lawyer says these guys are facing seemingly endless public humiliation. They say these guys are going to have to suffer this forever when they go on a date, when they find a job, when they get Googled. This case is going to show up forever. Yeah, but at the same time, maybe not the biggest thing. The bigger thing, the boat they used, not the boat they won. It might be the same boat. I don't know. But these guys are also they may get sued. If I was running a fishing competition and I gave them any prize, I'd be suing them at this point for the money. If I gave them a $500 prize, I'd be suing them for the $500. The other thing is that if these guys are ever going to, apply for a tournament again, I can tell you that the tournament organizer will probably be like, no, go F yourself. Now, the article I was looking at was interesting because it leaves out something else. Another article on CNN states that they'll serve 10 days in jail and 6 months probation. So that was left out on the other one. So that makes no sense to me. Here's a picture of the weights that they were pulling out and the fish that they were pulling out of this. This is a really good question. Am I streaming next Monday? Next Monday, I will not be able to stream. Next Monday, I'm going to be traveling. Can't really give details on the travel at this point, but next Monday I will not be able to stream. So yeah. All right. Yeah, and they had been set to win $30,000 until the director became suspicious. Yeah, it's a problem. All right. Imagine serving 10 days in jail for cheating. I can say that in Canada, you can end up serving serious jail time for cheating at play. It's a whole separate crime of cheating in in a game. I'm just actually doing a quick Canley search as to cheating at play. I'm going to find one that is newest. I'm just trying to find a sentencing decision. All right, we got Queen and Wu. Crap, it's in French. I don't want to go through French on stream. Criminal record. Where is a good cheating at play case? I think I covered this one on a stream. Reesbury. Does it actually have the sentencing? Where is the sentence on this one? Nope, doesn't have a sentence. I gotta find. Sorry, give me 1 second. I'm trying to find a good sentencing decision on cheating at play. Here we go. Nope, that's not it. All right, I can't find one easily right now, and we're live on a stream, so yeah. You can get sentenced to jail for all of this stuff. It's entirely possible, and I'm just looking here. Yeah, this one doesn't have a sentence either. So even though it's in French, you can get like real jail time on all of that. So don't cheat. Don't cheat at in casinos. Don't cheat in anything like that. And yeah, this is yeah, they were so stupid. A small amount of weight can go unnoticed, but you get used to knowing what a fish should weigh. They were adding poundage, not ounces. Yeah, the in one of the articles they noted that the guy looked at it and assumed that it would be like a 4-pound fish, and then when he weighed it, it came out as a 7-pound fish, and he was like, "That makes no sense. How is this fish 7 pounds?" Yeah, if it's nearly twice the weight it should be, somebody's going to get suspicious on that one. All right, I will cover some last super chats, and then we will wind this up and go to bed. Or at least I'll go to bed. Well, no, I'm lying. I'm going to wind this up, and then I'm going to not go to bed for a few hours. Burrowberries, RE the spines, magnesium sulfate paste for drawing out buried splinters, also works for drawing out boils. Good to know. I will have to check that out. Nice to catch you live at the end of the stream. Nice to have you here. Been going for a while. Much appreciated. Was it a Bassmaster tournament in northern New York? It was Lake Erie Walleye Trail Tournament. So not Bassmaster. It was a walleye tournament. So, all right. Oh, the puns. You might think it's net, but cheating at fishing is a really big deal. Oh, that's yeah, that's terrible. All right, I'm gonna wind this up. We're almost at 5 hours. I'm gonna hit the wind up thing, and yeah, fishing industry is no joke. It's territorial and competitive, so I get the seriousness. Yeah, if you ask a fisherman for a good spot to fish, you should fish anywhere but that place they tell you, because they will probably tell you all sorts of terrible things. All right. So good night, everybody. Won't be here next week for Monday, but I will see you 2 weeks from now. I'm hoping as well to get, I'm wanting to get some live stream gaming going for Roll of Law as well. Aussie J, thank you very much for the last minute super chat there. Thanks for keeping me company while working. You all made a long day so much better. Well, thank you very much. And also, check us out on Trials of the Century. I think we'll be on Rob's channel, I think, on Wednesday. And then we will see you later. All right. Cheers.